Good evening, everyone. You are most welcome to
Good evening.
today's session. You are most welcome to today's session of the. So before we begin, can we have one person say a word of prayer for us? One person can unmute and pray for us. Thank you.
Please, shall we pray? Father, in Jesus' name, we are thankful so much for today. We thank you for this opportunity given us. We ask that even as we study, you will give us the grace to understand and you will teach our teachers to teach us. We give you glory. In Jesus' name, we pray with thanksgiving. Amen.
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 Amen. Thank you very much, Sandra. So I am Nana Abba Kwesenwa Odum, SRC General Secretary for the Ghana School of Law. And before we go into today's session, we would invite our Vice President for the UPSC campus, Mami Ekuya Otinowa Odru, to give us the welcome address.
Hi, everyone.
Please, if you are here.
Yes, I'm here. Hi, everyone. Good evening. So, as Nanaba mentioned, my name is Mami Ikwa Otinowa Ujuru. I am SRC Vice President for UPSC Campus, and I just want to take a moment to welcome you all to today's session. So this is just an SRC initiative, and on behalf of the SRC, I just want to welcome you all to these entrance exam classes. We are looking forward to having you join our Ghana School of Law family by October or November this year. So while we organize these classes, I just want to encourage all of you that do not approach the entrance exam with fear, because though it's challenging, so many people have done it before you. So you do have the right tools to succeed as much as you are willing to put your mind to it and work hard. So please make the most of these classes. Ensure that you ask all the questions that you have, and please compare notes, be each other's helper, and then all together you all will make it. So please be sure to keep your mics muted and don't disrupt the class. And if you have any questions, feel free to reach out to any of us executives. So again, all the best, and we wish you the very best. As an SRC, we are rooting for each and every one of you. So thank you once again and welcome.
Thank you.
Thank you very much, Otinawa. We are most grateful. Now I would invite the organizing secretary, Gloria, to also give us a brief remarks. Gloria, please, if you are here, kindly unmute and give us a brief remark. Hello, please, can you hear me?
Yes, we can.
We can hear you loud and clear.
I think Gloria has not yet joined the call. However, our organizing secretary is Gloria Abili, and she's in charge of this whole session. So she's but on her behalf, I would stand in the shoes of the SRC to sincerely apologize for yesterday's learn a lot, and we hope you find a place in your heart to forgive us as well too. Thank you very, very much. Now, I would invite the Vice President for Makola Campus, Don Emmanuel Agbanyo.
Yeah, thank you, Honorable General Secretary.
Good
evening.
I would invite the Vice President from Makola Campus, Don Emmanuel Agbanyo, to introduce the speaker for today, to introduce our tutor for today. Don,
yes, thank you. Yeah,
please,
thank
if you are
Nanaba, our Honorable General Secretary.
Hello, Don. Please, we can't hear you. Don, please, you are muted.
Okay, can you hear me? Can you hear me?
Yes,
Hello?
we can.
All right.
Yes, we
Yes,
can.
we can.
Don, please, we can.
Yes, sorry about that. If you haven't heard me, my name is Don Emmanuel Agbanyo, the Vice President for Makola Campus. And good evening, everyone. It's my pleasure to introduce our facilitator for tonight's session on the law of tort. It's one person who has taken all of us through, except that he's right now waiting to be called to the bar as a professional lawyer. But while she was even a student, she took some of us through and we made it to the Ghana School of Law. And I know with her help, you also make it to the Ghana School of Law. Her name is Maria Abrefi, with a strong academic foundation from Dwabin Senior High School, Ejisu Dwabin. Maria Abrefi pursued her LLB education at Moncrest University College in Accra. Because of her exceptional legal acumen, she was recognized when she emerged as the best female contestant in the Law Challenge 2021. Currently, Maria Abrefi is a dedicated lecturer at Prof. Brain's Institute, sharing her knowledge and inspiring students. And same class, she has taken her through part 1 on many of the subjects that we currently wrote and passed. Tonight, Mary Abrefi will guide us through the intricacies of the law of tort, drawing from the expertise and experience she has gathered over the years. Let's give her a warm welcome and engage in a productive discussion as she takes us on this journey. See you at the Ghana School of Law as you prepare for this entrance examination. Thank you very much.
Thank you, Senior.
Thank you so much.
Thank you, Don. So, please, our facilitator, my lady Abrefi, please, you can take over. Thank you.
Good evening, members. Please, how are we doing?
We are doing
Good
well.
Good evening,
Good evening, my lady.
Doing well.
Afternoon,
Me, my lady.
wonderful. We are doing well. Wonderful, yeah,
Yeah, well. Good evening, my lady.
As all of us talk.
All right. So I want to, first of all, thank the SRC of the Ghana School of Law for this very opportunity. My name is Maria Abrefi. Those that know me normally call me Auntie Agiba Abrefi or my lady Abrefi. The essence of my lady and my lord, and that is going to be our relationship. It is my lady, my lord kind of situation, because I was in courtroom one time and I heard someone refer to a judge as Your Majesty. That was the time that I made a resolution that any male that I see is my lord. Any female that I see is my lady. At least let me use this platform as a preparatory stage to learn, so that I don't refer to a judge as madam, or I don't refer to a judge as your majesty. Having that said, I really want to appreciate the entire team, that is the entire SRC body, for acknowledging and realizing that I can be of help to this just cause. All of you right here listening to me from the other side of the phone, I want to welcome you all to this particular session. I am very hopeful and I am praying that by the time we finish with this session, whatever it is that you have learned, you'll be able to put it in perspective. Whatever it is that you are yet to learn, you will be able to understand it, so that when you sit by your book and you are reading, it will become a bit easier for you. I do not take this opportunity for granted. You are the lawyers in the making. In some few years, which is not too far from now, in 2 years, when we are looking at the call sheet, it will be coming from some of you. So I deem it a great opportunity to be able to contribute to this just cause. Because once I'm contributing to this just cause, I know that we are raising legal giants. I know we are raising legal luminaries. And tomorrow, when one of you becomes chatrichikata of our time, I will be able to stand somewhere and tell my grandchildren that, yeah, penso chatrichikata, mechere na die. So that is just by the way. I'm so grateful and I take full responsibility for this opportunity. We are going to have a session that I believe and I hope that at the end of the day, it will be very beneficial to you. Call me my lady Abrefi if you want to ask a question. You kindly will have to raise your hand. I will acknowledge it and give you the opportunity to ask the question. It is going to be a fruitful session. We are going to have an overview of the entire law of torts as time may permit us. And then there is a strategy we will learn. And this foundation stage is very important to me, that I wish everyone else was here to be able to listen to it. But I'm hoping that even if they are not joining yet, they will join and then they will be able to benefit from it. I will first of all share a little secret with you. Those that know me from Prof. Brain Institute, I acknowledge all of you. You are very much aware of our little secrets, but I will share it with your colleagues also. And you too, remind yourself of our little secrets. The essence of this little secret is that it helps you even in preparation of your rules. That is, should you get a problem question. Even if it is not in your rules, in your IRAC, when you are using the IBC, it helps you when you get to the body of your discussion. So have an open mind. I am always of the opinion that he who relates the law to the things around him or her is able to appreciate it better. Let me give you an example. There are about 24 topics under the law of tort. I've sued my mother for all 24 of them. For all of them, she has been held liable. She has been paying damages as a start, right? So for all of them, she has been held liable, and she has been held liable, and she has been paying damages. So the point I'm trying to establish is that we are going to lay down the foundation. And this foundation stage is very important to me, because once you understand this foundation, whatever it is that we will do, we will only be building on it. And so you need to note this little secret. I am also, as part of my mandate, tasked to discuss with you or speak to you about anxiety. Now, I need to start with you with a word of prayer, but my lady Sandra has done that on our behalf. One of the greatest things I believe in, as far as this entrance exam is concerned, is the presence of God. The law has its letter. Equally, it has its spirit. So we must acknowledge that. Now, there are 24 topics in the law of torts. You must note, at least, not less than that, you must know each of them. How do you make it very easy to understand? And how do you make it very easy to comprehend? How do you make it very easy to understand, and how do you make it very easy to comprehend? For each of the topics, when you pick them down, and I need each and every one of us listening, as far as you are a candidate, to put what I'm going to share with you down. You may need it someday, which is not too far from now. So for each of the topics, when you pick each one of them, you must ask yourself, do I know these things about that topic? If you know these things about the topic, you can actually, as it were, proceed to the next one. Now, you may not find all of them under the topic, but the likelihood that at most, if you can get a question that has, or a topic that has all of them, this is the most it can go. So we are going to look at it. Remember, I am here to introduce you and take you over the substantive law, so that anyhow you get the question, you will be able to answer it. I believe in knowing the substantive law. And once you know the substantive law, it doesn't matter how an examiner will put the question, you will be able to answer it. Relate the law to the things around you. Relate what we are going to share to the things around you. In your house, if your child hates you, sue the child for battery. If you go to church and your pastor says handshake and someone forcibly gives you a hug, sue that person hypothetically for battery. If your employer is doing something and you don't like it, you need something to work, he's not providing it, sue your employer under employer's liability towards his employees. Relate the things to the law to the things around you, and it will better help you to understand it. Now, the very first thing I need you to put down is a constitutional provision. And we have prayed, so I'm trusting God to help us in this journey. The very first thing is a constitutional provision. Now, the essence of this is to lay foundation. And I'll give you an example. If you are talking about false imprisonment and you have your Article 21 Clause 1G, you know that you are using that to lay foundation. So before the examiner will pick your script, the first thing they are seeing constitutional provision. Boy, you are mediagro. I was so part 1. So constitutional provision to lay foundation, that does not mean that if you don't have a constitutional provision, concord and fabricate, then you go and tell an examiner that Article 1 Clause 2, it speaks to defamation. You are a pathological liar. You are lying. But where you have a constitutional provision to lay foundation, you use it to lay foundation. The next thing you need to note is the nature of the topic. Now, the nature of the topic deals with the definition of the topic and some characteristics of it. When we talk about battery, what is it? When we talk about assault, what is it? When we talk about false imprisonment, what is it? It deals with the nature of the topic plus the characteristics of the topic. That is the second point. The third point I need you to put down is the elements of the topic. Dealing with the elements of the topic, we are talking about the things that the plaintiff must prove to succeed in the action. So you tell the examiner that for the plaintiff to succeed in an action in battery, he must prove the following elements. You don't list them, number 1, number 2, we don't list. Firstly, secondly, thirdly, but be cautious not to say seventhly, eighthly, sisem kakra, sisem kakra. So that is it for the elements of the topic. The things that the plaintiff must prove to succeed in the action. The next point is cases or case. Now, I understand that some people, their family people are with them. And so they can do one principle, 7 cases, we stand with you in prayers. But living legends, we too, we are here. One principle, one case. One principle, one case. Now, one case in the Kramirefi. Now, means problem. So at least one case, that is what makes it law. And the law of tort, the law of contract, just like any other area of law, is a game of cases. Your ability to support the principle with a case is what will make your script different and more rich than that of the other person. I need to lay this foundation because once I zone down to what constitutes battery, defamation, the very last topic. So you must pay particular attention. And then the next point is principles. Now, everything you will say about the topic is a principle of the law. So when you are defining direct act under battery, it is a principle of the law. But some of the topics have peculiar principles. So when you pick assault like this, you can have the gun rule, you can have the words negating an assault rule, you can have the lifting of the whip rule. They have specific principles thereunder. And so we will look at them. The last but one pointer is defenses. Now, we will treat a topic called general defenses, which applies to intentional interference with person and then land. But notwithstanding these general defenses, some of the topics have peculiar defenses. Like when you are talking about private nuisance, you would realize that you have the defense of prescription. When you are talking about the rule in Rylands and Fletcher, you can have the defense of an act of a third party or act of God. You must pay particular attention to them. And then finally on our little secret, finally on it is remedies. Now, of course, everybody will go to court for compensation, but there are some of the tortious actions that they need specific remedies. Defamation, the person may not need your money, but they will need retraction and apology. So you must state it. So it depends on how you get the question. Now you can get a question which is similar to our time, the 4 areas in one question. And you can get a question which is that of last year, a whole area of law on one topic. You approach them differently. If it is one, then it means that a lot of work is required. There's a general saying that to whom much is given, much is expected. IEC is the only exception. To whom less is given, much is expected. So for them, when they give you one area of law, they need you to talk about the things that they didn't even mention in terms of the defenses and everything. So this little secret that we have shared will run with us through the entire discussion on the law of torts. Now, I need you to note and I need you to pay attention to the fact that there are topics that you may not get all of them. It is not a problem. But at most, ask yourself, is there a probable constitutional provision? Do I know the nature of the topic? Do I know the elements that the plaintiff must prove to succeed in the action? Do I have at least a case or two to support? Principles undergirding that particular course of action, do I know them? Defenses, remedies, do I know them? Our little secret. It helps you in analyzing your rules. It makes your work more presentable. You have the opportunity of having access to this. Somebody may not have that opportunity. So please put this by the side. Even if you have studied, let this be a guide to you. Don't go and concoct a constitutional provision where there is none. Don't fabricate a case law where there is none. You are talking about the rule in Rylands and Fletcher. One case be and to see us held into 4 versus Attorney General. You are a pathological liar. Rylands and Fletcher and need to 4 versus Attorney General need to. So if you remember the case, state it. But if you don't remember, don't concoct and fabricate. It is better to say it was held. It has been judicially decided. The courts have held, than to say that and under the rule in Wilkinson versus Downton, the court held in the case of 2-4 versus Attorney General. You are lying. You are lying. Irredeemably gone. So please pay attention. But that does not also mean that question 1 to question 4, it has been decided. The courts have held. The courts have held. What your question 1 to question 4? One side case back, because my lady Abrefi said, if I forget, I'm talking about situations where you are so pressed that a particular case you cannot remember. This is the foundation we have to lay in respect of our discussion, in respect of the law of torts. Now, our discussion throughout is going to be guided by this. Whether I say it or I don't say it, you will find them there. It's not all the courses of action that you will find all of them, but at most, you must find these. With your kind permission, I will introduce you to the law of torts, and I will let you know that in respect of the law of torts, it is a civil law. Of course, it's not a public law. It deals with relationships between private persons, wrongs done by a private person to another private person. Now, I need you to note that when we pick the law of torts, there are certain aims or functions of the law of torts, the purpose of the law of torts. What does the law of torts stand for? And you can talk about at least 4 of them. The very first one is compensation. Should you get a question and an examiner says, state the aims of the law of torts, or state and explain the aims of the law of torts, you know that your very first one that you are talking about is compensation. The law of torts is there to provide compensation to aggrieved persons from the wrongful conduct of another person. When you look at Article 14, Clause 5 of the 1992 Constitution, a person who has been unlawfully arrested, restricted, or detained shall be entitled to a compensation from that person That is the provision of the law. And that is the essence of the law of tort, at least one of them. The second one is deterrence. Now, deterrence may be in the nature of general deterrence or specific deterrence. It is general deterrence when it is serving as a warning to the entire public or like-minded persons that such conducts cannot be entertained. It is specific deterrence if it serves as a warning to the tortfeasor himself. You will hear me use words like the tortfeasor. When I talk about the tortfeasor, I'm talking about the person perpetuating the tortious action or the tortious conduct. If you have any question, please, I believe that the executives of the Ghana School of Law who has graciously put this together will be monitoring the chat session. If there is a question and I happen to be carried away because I don't see it, then you can draw my attention to it. As much as I can, I will address it. I need you to note that it also serves as deterrence, to serve as a warning to the particular person or to serve as a warning to the entire public at large or like-minded persons. So you may note that. And then the third one is appeasement. Even when you offend the gods, you are made to appease them. Appeasement is meant to prevent revenge because there are some people you dare not step on their toes. If you offend them and you don't do anything to appease them, they will pay you back 99 times. So to appease such persons, the law of tort steps in to provide them with some remedies. And finally, just as any other branch of law, the aim of the law of tort is to achieve justice. The ends of the law is to achieve justice. And so you must pay particular attention to that. Having introduced you to the aims or the purpose or the functions of the law of tort, I think it is a good point and it is a safe space to land on the very substantive topics, starting with battery. Now remember, our little secret, constitutional provision, if any, nature of the topic, that's the definition and characteristics, elements of the topic, the things that the plaintiff must prove to succeed, a case or cases, principles of the law, and then defenses and remedies. You must pay particular attention to this. Now let's look at the tort of battery. And I need you to, yes.
Hey, lady.
Yes, yes, my lord.
Please, if you can kindly beat too fast, please.
If I can do what?
Be a bit slow.
Okay.
Yes, it's like you.
In moderators, please, is it being recorded?
Yes, please, it's being recorded, my lady.
Because I've been informed, unless I'm mistaken, that I have only a day to finish the law of tort. Is that not so?
Yes, please. So we are recording, so everyone can go back and listen to it. So no problem.
Okay.
Thank you.
All right. So, my lord, please, I hope that will help you a bit. But as many of the things as you can put down, you may want to put them down. But I am guided. I am guided. So if you don't get anything, there will be no point. So I will slow down. I may be carried away some way, somehow. But solving an issue. So let's look at the tort of battery. But the aims, I think you should have gotten it. Compensation, appeasement, deterrence, and then justice. These are the aims. Now let's look at battery. When you look at Article 14, one may use Article 14, Article 15 to lay foundation. A person is guaranteed his liberty. Article 15, a person is secured his rights of dignity or to dignity. So one may say that to that extent, the person his body must not be intentionally or unlawfully be interfered with. Now, there is something I need you to note, and I want to introduce you to it. Normally, if I want to couch a definition for the topic, I would rather go and look at the elements and know the elements of the topic so that I will be able to use my tool from and to join the elements together to couch a definition. The essence is that if my family people should take part of the elements from me, I can deduce the elements from the definition that I have given. So you must pay attention. And so when we speak of the tort of battery, It deals with a situation where the defendant, through his direct and voluntary act, either intentionally or negligently causes physical contact with the body of the plaintiff. Where the defendant, through his direct and voluntary act, either intentionally or negligently causes physical contact with the body of the plaintiff. Now, the position of the law is that battery is actionable per se. And I'll be using this phrase a lot, so let me explain what it means. Actionable per se means that you need not prove damages, but actionable upon the case means that you need to prove that you have suffered some damage to succeed in the action. So if it is actionable per se, it means that the mere touching of the body of another constitutes an actionable tort. Battery is where the defendant, through his direct and voluntary act, either intentionally or negligently causes physical contact with the body of the plaintiff without that plaintiff's consent. I need you to note that be that it is actionable per se, the plaintiff need not prove damages to succeed in an action. So if you are going by our little secret, we have ticked constitutional provision, we have ticked the nature of the topic. What it means is that we move on to the elements that the plaintiff must prove to succeed in the action. Now, when it comes to battery, for the plaintiff to succeed in an action in battery, he must prove the following elements: direct act, voluntary act, state of mind, physical contact, positive act, and lack of consent. So generally speaking, there are 6 elements that the plaintiff must prove to succeed in an action in battery. The very first element is that it was the direct act of the defendant that brought about the physical interference with the body of the plaintiff. Secondly, that it was the voluntary act of the defendant that brought about the physical interference with the body of the plaintiff. Thirdly, that he had the requisite state of mind. Fourthly, that there was positive act. Additionally, that there was physical contact. And finally, that there was lack of consent. We take these elements after you have listed them, so that even if you don't finish discussing all of them, the examiner may think that they collected your paper. Meanwhile, maybe you didn't know, so you are deceiving the examiner. Don't deceive the examiner, you may end up deceiving yourself. Don't attempt that. So at least when you list it, the examiner will know that you knew it, but maybe time. So there are 6 elements: direct act, voluntary act, state of mind, physical contact, positive act, and lack of consent. Now let's pick them one after the other. The very first element is that the plaintiff must be able to prove that it was the direct act of the defendant that brought about the physical interference with the body of the plaintiff. What this means, and the principle of the law, is that it must be the immediate act of the defendant that brought about the physical interference with the body of the plaintiff. Scott versus Shepherd. By now, you must have seen this case. The firecracker case, the court said that it was the immediate act of the defendant that led to the lightning of the squib and being thrown into the crowd for the third party to involuntarily throw it, and it caused danger to the eye of Mr. Scott. There was liability. The second element is voluntary act, that it was by virtue of the voluntary act of the defendant that brought about the physical interference. Now, voluntary act deals with controllability. Who was in control of the instrument or the item that brought about the physical interference? It deals with controllability. It goes on to say, therefore, that if my Lord Agbanyo holds my lady Nanabe's hand to slap Harirata, then it means that Nanaba will not be the one liable for battery, because at the material time, she was not in control of her hand. The proper person to sue should be my Lord Agbanyo, because he was in control of the hand of my lady Nanaba. That is the point we are trying to establish. Gibbons versus Pepe. He who is in control of the act is the one that will be held liable. And if you are asking yourself the Gibbons and Pepe case, it is the horse that the other party whipped the horse so hard that it bolted. The court made a firm opinion. If you were in control of the horse, you are liable. But if you were not, the liability is denied. The very third element is that the plaintiff must be able to prove that the defendant had the requisite state of mind. Now, the principle of the law is that the law requires the defendant to have acted either intentionally or negligently. So, in terms of state of mind, there is the requirement for either intention or negligence. Where intention is vitiated and negligence is also vitiated, the action is bound to fail. Stanley versus Powell, they were in the habit of shooting bows, and then one shot and it rebounded and caused danger to the plaintiff. The court said there was no intention, there was no negligence. The action fails. The next one is positive act. The defendant must have engaged in some positive act. The principle of the law is that not doing, generally speaking, is not trespass. There must have been some overt act undertaken by the defendant for that defendant to be held liable. As you are sitting by your device with your pen and your paper, seeking to put something down, will somebody sue you for battery? No, because omission to act will not constitute battery. But as a mother, if your child disturbs you so much that you pick benkudade, slippers, papa, water, whatever it is that you get, and you throw it at this child, hypothetically, that child will sue you for battery because you must have done some overt act. The last but one element is that there must be physical interference. Where there is no physical contact with the body of the plaintiff, the tort of battery is likely to fail. It is bound to fail. Here, the law is that the physical interference can be through body to body or through the use of an instrument. And so he who acts by another acts by himself. The agency relationship, key facet per alim facet per se. So if you use an instrument to cause an event, you can even check from the criminal perspective, section 13. He who uses an involuntary agent to cause an event is deemed to have caused it himself. Similarly, if you use an involuntary agent to cause an event under the law of tort, you will be deemed to have caused it yourself. The case of Fagan versus Metropolitan Police Commissioner. He drove and stopped on the foot of the police constable. The court said that the car tire was an extension of the body of the plaintiff. Remember, of the defendant, remember that the instrument that you use will be considered as an extension of your body. And then you can have the case of R versus Cotsworth, where he spat on the plaintiff. The court said that the saliva became an extension of your body. Now you must note that the very last element is the element of lack of consent. Don't say that the last element is consent. It's not consent. It is lack of consent. Unless when you state consent, you are going to explain it to mean that it is not the presence of it, but the lack of it. But if you don't want problem, lack of consent. The general principle of the law is that he who consents to a thing cannot complain of trespass. And so if you have consented to the physical touch, you cannot complain of trespass. The case of R versus William, we all know this case, Presbyterian choir master. Voice production ended up in sexual intercourse with one and indecent assault on the other. Consent was vitiated. Nash versus Sheen. He said, I want sporting waves. I want waves. And the gentleman exercised his discretion to dye the hair, for which reason there was unpleasant consequences. The court took the view that same amounted to lack of consent. Remember that when we were stating the elements, indirectly we were adding the cases, and every principle that I stated is a principle of the law. Don't forget that in terms of the defenses, we will treat it generally under general defenses, and then the remedies primarily compensation. With the kind permission of the House, I will move on to assault, unless there's a question which requires that I address it. If there is no question, respectfully, I will move on to assault with your kind permission. That is the essence of assault. It is the essence of assault. Putting unreasonable fear in another person. Generally speaking, we say that assault is the apprehension of imminent physical contact. As a general rule, assault has all the elements of battery except physical contact. Now, someone may choose to just list them and not to explain it as the elements of assault, because assault has its own elements as established in the case of Reed versus Coker. So it is the apprehension of imminent physical contact or imminent physical battery. And it has generally all the elements of battery except physical contact. That is direct act, voluntary act, state of mind, positive act, lack of consent. You may want to state it that way. But assault primarily, when you are looking at it from the definition as stated in the case of Reed versus Coker, assault is where the defendant issues a threat of harm or violence, coupled with exhibition of an intention to carry it out and ability to carry out the threat. Now, there be a mekasa sabio, obi a yetwa ne nsa twa ne nan ka che ose mebo wasum, agise honhom asem no oka. There will be no ability to carry it out. So, for the plaintiff to succeed in an action under assault, the courts have held, in the case of Reed versus Coker, that three major elements must be proven. The very first one is threat of harm or threat of violence. And this can be by words or by conduct, threat of harm or violence. The second element is that there must be exhibition of an intention to carry out the threat. It's either the person is walking towards you menacingly, threateningly, or the person is tucking up their sleeves. Something must point to exhibition of intention to cause or execute the threat. And the very last one is ability to carry out the threat. I need you to note that Sabi, then you go to court that you were put to fear. And you know that the Lord does not deal with spiritual matters. So there, ability to carry out the threat will not be present. The action will fail. But kwateni, sebi, kwateni ka so betwa okotwa, pebebi fa, because osibebuagum, osibebuagum. That is the point I'm trying to talk about, because there will be ability. Perhaps there will be threats. There will be exhibition of intention, and there will be ability to carry out that particular threat. There will be ability to carry out that particular threat. That is the point we are trying to establish. These are the three major elements that a plaintiff must be able to prove to succeed in an action in assault. You must pay attention that in Reed versus Coker, the defendant is the landlord, the plaintiff is the tenant. The plaintiff is owing the defendant, and so he goes onto the premises with three macho men. And they said, you either leave or we will break your neck. And they start to tuck up their sleeves. The court took the view that same constituted assault because there was threat of harm. You either leave or we will break your neck. There was exhibition of intention. They were taking up their sleeves. There was ability to carry out that threat. This is the position of the law. This is the requirement of the law. Stevens versus Myers, the parish meeting case, where he was walking menacingly towards the chairman with his fist clenched. He says that, I would rather pull you out of your chair than to be moved out, when there was a motion that he be moved out. The court took the view that there was, threat of violence, exhibition of intention, and ability to carry out the threat. Now we close the chapter on what assault is, but there are some principles undergirding assault, and you must note. Now, an examiner can give you a question and it is on one of these principles. You know that you cannot go straight to talk about the principle. You must lay your foundation on what constitutes assault. Then you add that the principle of the law is that so and so and so. So we are going to talk about four of them. The very first one is the gun rule. The position of the law, whether or not pointing a gun at another will constitute assault. The position of the law, as started in the case of Blake and Bernard, is that to point an unloaded gun at another constitutes no assault. Guess what? The element of ability to carry out will be absent, and so there will be no assault. But in Attorney General versus Miller, the court said that to point a loaded revolver at another, such that that other person is put to fear, can constitute assault. Then you settle the matter eventually with the case of R versus St. George, where the court made it clear and emphatic that whether loaded or unloaded, a pistol is a pistol. Now you will have tetafly, chachafly, and tontom kakape, wosuro kakape, esurekura. Then you point an unloaded gun at such a person. That is what assault seeks to protect. Wuyi obi akoma efri nebo abehye ne nase na akotwero we exam paper ne so. Assault seeks to protect a situation where wuyi obi akoma efri nebo abehye ne nase to wait. To wait. No de to wait ahye ho bechire mu obrofo. This is only meant for you to understand. There is no to wait. Wuyi na akoma efri nebo abehye ne nase bia. It is only meant for you to understand. Unnecessary fear. That is what we are talking about. And so, whether loaded or unloaded, a pistol is a pistol. Our verse is in George. And so, to point it at another such as that, it will put that other person in reasonable fear, constitutes assault. You close the chapter on the gun rule, you come to the words negating an assault rule. And this is the one that students like. Because of the case of Tubaville versus Savage, of course, the principle of the law is that where a person is guilty of assault, but he accompanies the assault with certain words which negate that assault, there will be no liability. So the person will tell you that what it means is that you are fortunate your father is the king. I would have killed you today. The essence is that because of the condition they have given, it has negated the assault. The effect is that it exculpates that person from liability. Tubaville versus Savage. You are fortunate it is the assize's time, or had it not been the assize's time, I wouldn't have taken those words from you. Had it not been the assize's time, I wouldn't have taken those words from you. The court took the view that same had negated the assault. And then we will have the lifting of the whip rule, which is when you get a fact pattern and someone is chasing another with a lifted whip. The courts have taken the view that the principle of the law is that to chase another with a lifted whip constitutes an actionable assault. In the case of Morton versus Shoppy, the court took the view that to chase another with a lifted whip constitutes an actionable assault. I need you to note something that I've been doing. You see, you state the principle of the law first, then you support it with a case. Now, people will be taking extra sheets. People will be flipping pages. If you want to also flip pages, you state the principle. This was held in the case of Morton versus Shoppy. Then you repeat the principle again, so that you will flip page. You will flip page. But if you don't want, then you can also state that this was held in the case of Morton versus Shoppy. Yes. Is there a question? All right. The point under the lifting of the whip rule is the case of Morton versus Shoppy. To chase another with a lifted whip constitutes an actionable assault.
I was coming in with my plea, please. I think
Yes.
I appreciate the fact that we are behind time and you would need to cover a lot. But the speed to some of us, you have to make provision for us to be able to follow you. Like if you could see.
Counsel, senior, the thing is being recorded, so later you can take your time and listen to it.
Yeah, but we are dealing with time here. We have a lot to cover within this short space. So it's important to also grab what we are doing right now as we move.
Please,
I beg you.
let's proceed. I am guided respectfully. So the point I'm trying to establish is that the principle is that to chase another with a lifted whip constitutes an actionable assault. Constitutes an actionable assault. Now, that is the point of the law. And then the last principle under the assault is words rule. The old position of the law was that mere words per se could not constitute assault. Mead versus Belt. Mead versus Belt. But the new position is that mere words can constitute assault so long as they put the other person in reasonable fear. So long as they put the other person in reasonable fear. R versus Wilson. Some of my people from Prof. Brain Institute, please help me, or any other person at all, respectfully, any other person at all can help me and be putting the title of the cases in the chat session. Some of us may be hearing it for the first time. So at least if they have, Pasolo, you are doing well. Prosper, you are doing well. I appreciate you guys. And so that some other people will also be able to follow. We close the chapter on the thought of assault. All right. I will be guided, honestly. I've taken it into consideration. I am almost always carried away by the fact that I want to finish all the topics within the period that has been given me. So if I don't take care, I may not finish, and I would like to finish, but I am guided. Now, the point I need you to note is that when you close the chapter on assault, then you can move on to, as it were, false imprisonment. False imprisonment. In respect of constitutional provision, you can look at Article 14. A person is secured his liberty. Article 21, Clause 1G. Article 21, Clause 1G. A person is secured his freedom of movement to and outside Ghana, within and outside Ghana. And so you must pay attention and you must note that where a person is secured his fundamental freedom of movement, it is on this basis that if the defendant restricts the movement of a person, if the defendant incarcerates a person or detains a person for no matter how short a time, so long as it is without lawful justification, excuse, or authority, it will amount to false imprisonment. Now, the position of the law is that false imprisonment deals with the wrongful restriction, detention, or incarceration of a person without lawful justification, excuse, or authority. Now, the position of the law that you need to note is that for the plaintiff to succeed in an action under false imprisonment, he must prove primarily two major elements. All others can be subsumed thereunder, but two predominant elements. The very first one is that there must be complete restriction of the movement of this person. What this means is that it deals with the totality principle. And the law is that for there to be false imprisonment, the restriction must be total. The restriction must be total. The restriction must be total. It must be complete without any reasonable means of communication, without any reasonable means of exit or reasonable means of escape. The position of the law is that for it to constitute false imprisonment, the restriction must be complete, it must be total, without reasonable means of escape. So what the law therefore is that where there is a reasonable means of escape, the action is bound to fail. If there is a reasonable means of escape, the action is bound to fail. And so there must be no reasonable means of escape. The case of Baird versus Jones, the case of Baird versus Jones, Baird versus Jones, Baird versus Jones, the case of Baird versus Jones, the courts have taken the view and the courts held that because it is only one side of the bridge that was blocked and the other side was open for the exit of the woman, it constituted no false imprisonment because the restriction was not complete. The restriction was not total, it was not complete. You must note and you must pay attention that false imprisonment need not occur within the four corners of a room. In the case of Warner versus Rutherford, the courts have taken the view that false imprisonment can occur anywhere. It can occur anywhere. In traffic, at church, anywhere at all, it can occur. So that is the case of Warner versus Rutherford. And then you can have also the case of Wright versus Wilson. If there is a reasonable means of escape, there will be no false imprisonment. The second element to prove to succeed in an action in false imprisonment is the element of falsity of the imprisonment. What it means is that the imprisonment must be without lawful justification, excuse, or authority. The position of the law is that if there is a lawful justification, excuse, or authority, it will not constitute false imprisonment. When you look at Article 14, there are instances where the imprisonment of a person will be lawful. For instance, for educational purposes, boarding house. If you have been convicted by a court of competent jurisdiction, your imprisonment can be lawful. If you are suffering from a venereal disease in its communicable form or a pandemic, Ebola, COVID-19, you can be imprisoned and that will be a lawful imprisonment. But the requirement under false imprisonment is that the imprisonment must be unlawful, such that it must be false, such that it must be without lawful justification, excuse, or authority. Here, we have the case of Sandolph versus Alford. The plaintiff went to eat at the defendant's eatery. Unable to pay, the defendant seized his things and then prevented the plaintiff from leaving. The court said that that was unlawful, and so there was an action in false imprisonment. You must also note that the case of Head versus Weedle Steel Company Limited, the miner, not a child miner, but Galamsey miner, he went to the pit and then requested that he be brought out of the pit. But the court, they said that the machine, they don't operate it randomly like that. And so he was kept inside the pit. When he sued, the court said that the period that he was kept inside the pit, that period was lawful justification because he had already contracted to be down there. One principle under false imprisonment that you need to note is the fact that there used to be the position, and it deals with whether or not knowledge of the imprisonment is material. Must the person being imprisoned be aware that he is being imprisoned to succeed in the action? The position of the law used to be hearing versus Boyle, hearing versus Boyle, hearing versus Boyle. The position of the law used to be that false imprisonment, the imprisoner or the person that has been imprisoned must be aware of the imprisonment. And so their knowledge of the imprisonment was material. It was material. But when you look at the case of Graham White, that Mearing versus Graham White Aviation Company, Mearing versus Graham White Aviation Company, the court held that imprisonment, the knowledge of the imprisonment was immaterial. Knowledge of the imprisonment was immaterial. And so you need not be aware of the imprisonment before you can succeed. So without lawful justification, excuse, or authority, that is false imprisonment. The moment you see a fact pattern, somebody is locking somebody somewhere, or somebody is restricting the movement of somebody somewhere, false imprisonment can lie. You must be guided. And you must know these elements of it. And then as we were stating the elements, we were discussing the cases equally. We were talking about the principles of the law. For defenses, we would discuss it under general defenses. With the permission of the House, and I hope that at least I've checked the pace. I hope that I've checked the pace. I'm always of the opinion that so if you don't get it, I must take that into consideration. So I have the article is Article 21 Clause 1G. Article 21 Clause 1G. So let's move on to the next topic with your permission. Unlawful arrest. Unlawful arrest. For purposes of entrance exam, you must know what unlawful arrest is. You will do a bit of it in criminal procedure in part 1, but you must know what unlawful arrest is. The moment we say that it is unlawful arrest, it means that there is a law that lays down the lawful arrest, how arrest should be effected, the procedure for effecting a lawful arrest. It goes on to say, therefore, that any form of arrest contrary to the laid down procedure by law can constitute unlawful arrest in the eyes of the law. What it means is that unlawful arrest is any form of arrest which does not follow or comply with the laid down procedure for effecting arrest. Now, when you are effecting arrest, I need you to note, one of the instances you will see unlawful arrest, follow me to the station. My boss is inviting you. Can they see traffic lights? Nowadays, they don't say anything. They will just open the front seat and sit there. And they will tell you to drive to the station under the guise of having arrested you. That is not unlawful arrest. That is not lawful arrest. The law lays down the requirement, the procedure for effecting lawful arrest. And the position of the law can be found under the Constitution, at common law, and in statute. So under the Constitution, your reference point is Article 14.2 of the 1992 Constitution. Article 14.2 of the 1992 Constitution provides that a person who is arrested, restricted, or detained shall be informed immediately in a language he understands, the reason for his arrest and of his right to a lawyer of his choice. The last part, students tend to ignore it. And of his right to a lawyer of his choice. So when you get a fact pattern and somebody is whisking another away under the guise of follow me to the station, Article 14.2 has not been complied with. The position of the law is that you must inform the person being arrested, restricted, or detained immediately in a language he understands the reason for his arrest and of his right to a lawyer of his choice. Non-compliance with this procedure, you and I agree that it will amount to unlawful arrest. At common law, your case of Christie versus Lichinsky.
Sorry. So what about if the person sits in the car and say, "Follow me to the head office"? Isn't that a way of letting you know you have been arrested or something?
Follow me to the head office is not a crime. Follow me to the head office. There's no crime called follow me to the head office. When you look at the constitutional provision, it says inform the person the reason for the arrest. Unless you can show me a section or you can provide a section under Act 29 or any other law that criminalizes follow me to the station.
So what about when somebody takes policeman takes, it says bring your license. Merely your license, it says under arrest.
So that one may be that you are under arrest. He must inform you why you are being arrested. And that may be that you are breaching traffic regulation by using invalid license. That may be an offense defined under the Traffic Regulation Act. That may be an offense. But those people that they will just look at you without saying anything and they'll tell you, follow me to the station. Those are the people that I'm dealing with. And the Kaneshi traffic light one, they will not tell you anything. They will open the front seat and sit there. Those are the kind of... Yes.
And also to add a small ingredient there, I think this matter was settled in the Asante versus the Republic case, where the police officer...
If you were to give me about 20 seconds, I would have addressed that case.
Very well.
My lady, I think the questions are too much. They should wait for you to land.
My lady,
Exactly. The questions are too
The questions are too much. The recording will be there, so proceed. We have a lot of things to do. The questions are
my lady. Please,
yes, my lord.
Questions. We'll take questions after the session. So I think that everyone should exercise patience so that you can finish with the course.
All right.
And you can drop your questions in the chat box as well. She'll definitely respond when she's done.
So that you don't forget.
Yes.
That you don't forget. All right. We are in this together. Remember, everybody here, we are in this together. So the point I'm trying to establish is that the constitutional provision under Article 14.2 says that you must inform the person immediately in a language he understands the reason for the arrest. The reason for the arrest there is the offense. That's why they will come and tell you that you are under arrest for the murder of Ochibon Petel MP or for the murder of Agona Bobikuma Slay Queen. Then they will mention the name. Then they will say that you have the right to remain silent. For everything you will say will be used against you in the law court or in the law, we are very much aware. Then they will tell you that you have the right to call your lawyer. That is how arrest should be effected. Article 14, it is clear, unambiguous. Tell the person why you are arresting the person. Follow me to the head office is not a crime. So it cannot be a proper way of effecting arrest. Menkasa koni police me being challenge you or yes so that but we are learning the law. As students of the law, we learn the law as it is. But on the ground, a lot of things do happen. But let's go and pay attention. Now the point is that is it for Article 14.2. At common law, you can rely on the case of Christie versus Lichinsky, where the courts reaffirmed the position that in effecting arrest, you must inform the person the reason for the arrest. Christie versus Lichinsky laid down two exceptions. The first exception is where the person is caught in flagrante delicto. Now, you are raping somebody. They are seeing you doing sawmill up and down. The person is resisting, shouting. They are seeing you caught in the act. Everything is clear. What do you want them to tell you again? Armed robbery. You are caught with the weapons and everything. When you are caught in the act, they may not tell you the reason. And if you make it impossible to be so informed, secondly, they may not tell you the reason for the arrest. So that is that. These are the two exceptions that Christie versus Lichinsky recognizes. Then you summarize it with the position under Section 3 of the Criminal and Other Offences Procedure Act, 1960, Act 30. Section 3 says that, no, you don't state the common law position before the questions are there, I'll address them. So the point is that Section 3 of Act 30, it says that in effecting arrest, it is to the effect that when you are effecting arrest, you must touch or confine the body of the arrestee unless that arrestee subjects to custody. So maybe this person is an MP and the person is saying that, oh, let me follow you. Don't create a scene. So the person says, I will follow you. And you don't do that. That is how arrest is effected. Now, this is how arrest is effected by virtue of the constitutional provision, common law position, and then statutory provision. Now, I need you to note that where there is unlawful arrest, the effect of it is that the arrestee can use reasonable force to resist the unlawful arrest. Asante versus the Republic, wabono, police in any fani hudi, wabuna fani hudi, because the court came to a conclusion that he was using reasonable force to resist the arrest, or the person may choose to sue for unlawful arrest. I need you to note this, that anything contrary to this constitutes unlawful arrest. When you see it in a set of facts, and it is walking like unlawful arrest and it is quacking like it, most definitely it will be unlawful arrest, and you must pay particular attention to it. We close the chapter on unlawful arrest. There's a bit of arrest with warrant, arrest without warrant. You will do it extensively under criminal procedure. But once you know this about unlawful arrest, when you see something and it is contrary to what the law has stated thus far, you can confidently raise your area of law, unlawful arrest. And here we can move on to malicious prosecution, with your kind permission. The law is that if a person cannot be unlawfully arrested, then that person cannot be maliciously prosecuted. Malicious prosecution deals with those kind of situations. Me as Santini, so you people should permit me with the tree. No, I catch them and say we're raping a back for no reason at all. Baseless prosecution. Now, malicious prosecution deals with a situation where the defendant initiates or causes to be initiated a criminal prosecution against the plaintiff. Who was the accused person there? I need you to know that distinction. He was the accused person thereunder, and the defendant was the prosecution under the earlier criminal action. And now the accused person has become the plaintiff, where the defendant initiates or causes to be initiated a criminal prosecution against the plaintiff, which criminal prosecution terminates in favor of the plaintiff, and it was initiated without any reasonable or probable cause. It was initiated maliciously, for which reason the plaintiff has suffered some damage. Now, malicious prosecution, unlike the others, is actionable upon the case, because if you notice from the elements, one of them that you have to prove is the element that the plaintiff must have suffered some damage. In the case of Musa versus Limo Wulana, the court laid down the elements of malicious prosecution. I will take them one after the other and explain them so that we can move ahead. The very first one is that the defendant must have initiated or caused to be initiated a criminal prosecution against the plaintiff. What this means is that it is either the defendant initiated the criminal prosecution himself, or he ordered, commanded, or was actively instrumental in bringing about the criminal prosecution. So when you get the set of facts, don't say that, oh, but I know not started yet. If somebody is behind the scenes acting like a shadow director, and he is pushing for the agenda that the person be prosecuted, that person can also be held liable for malicious prosecution. The case of Swedja versus Obey. Swedja versus Obey. If you are unable to prove that it was the defendant and no other person that brought about the the prosecution, the action is bound to fail. Similar position in the case of Danby versus Beardsley. And then the principle, still under the first element, is that to go with the police to point out a person alone is not malicious prosecution. In Nkrumah versus Foley. Nkrumah versus Foley. This is the position of the law. The second element is that the criminal prosecution must have terminated in favor of the plaintiff. In law, this means that it is either the plaintiff was acquitted and discharged, he was convicted of a lesser offense, or that the Attorney General entered nolli prosequi. And those of you who were, I'm talking about the representatives, UPSA campus, if Mr. Kobe taught you, you would know that the Attorney General can enter nolli prosequi. Anyhow you pronounce it, it is nolli prosequi, nolli prosequi. We are good to go. For purposes of malicious prosecution, the courts have held, in the case of Nanekua Mwabwate versus Yeboah, that where the Attorney General enters nolli prosequi, it means termination in favor of the plaintiff. You must note that termination in favor of the plaintiff can mean one of these three things. Either that he was acquitted and discharged, either that he was convicted of a lesser offense, or that the Attorney General entered nolli prosequi. Be guided and be looking out for some of these things. Nanekua Mwabwate versus, Yeboah. And then you have the third element, that it was initiated without any reasonable or probable cause. What this means is that the defendant didn't have any honest belief in the guilt of the accused person or the plaintiff. He didn't have any honest belief, or he didn't have any reason to believe the guilt of the accused, the plaintiff. It's either that someone is telling him, or that he has heard it somewhere. He didn't have any honest belief in it. And the fourth element is that it must have been initiated maliciously. Malice is the basis for malicious prosecution. And so malice means that he initiated the criminal prosecution for any other purpose apart from achieving justice. For any other purpose apart from achieving justice. It may be envy, anger, ill will, spite. Some of these things are only meant for you to understand. So that is it for the fourth element. And the very last element, be that it is an action upon the case, the law requires that the plaintiff must have suffered some damage as a result of that malicious prosecution. In the case of Saville versus Roberts, C.J. Holt mentioned that damage can be to your name, to your property, or to your person. Damage can be to your name, to your property, or to your person. Note that malicious prosecution is an action upon the case. Nolli prosequi is where the Attorney General says that they don't want to prosecute the matter again. It is a withdrawal or a reneging from the criminal prosecution. For purposes of criminal law, please mute Felix now. For purposes of criminal law, the Attorney General can go back, and this you will deal with it under criminal procedure. But for purposes of civil law in respect of malicious prosecution, Nanekua Mwabwate versus Yeboah, the court held that that also constitutes termination in favor of the plaintiff. You must close the chapter on malicious prosecution, and you quickly zone down to the rule in Wilkinson versus Downton. Now, how you would detect a course of action under the rule in Wilkinson versus Downton is that normally they will tell you in a practical joke, in a this one, April Fool kind of situations. The rule in Wilkinson versus Downton, April Fool kind of situations. Now, the rule in Wilkinson versus Downton deals with a situation where the defendant engages in a deliberate act or willful act or misrepresentation, which is calculated to cause harm to the plaintiff, and it actually causes harm to that plaintiff. It is a deliberate or willful act or misrepresentation calculated to cause harm to the plaintiff, and it actually causes harm to the plaintiff. I saw one of these pranks on the social media where a pope who was walking by the roadside, somebody has dressed like green grass and has hidden himself by the leaves. A whole pope, come and see something. That even I was watching it, I said, I will sue these people for under the rule in Wilkinson versus Downton. It protects persons from suffering nervous shock by virtue of the deliberate or willful act or misrepresentation of another person. Now we will deal with nervous shock under negligence. Don't be carried away. But this rule in Wilkinson versus Downton, how you would distinguish it from that of negligence, nervous shock, is that the rule in Wilkinson and Downton requires intentional doing of the thing. So that one must be deliberate or willful. But under negligence, it must be as a result of a breach of a duty of care. We will deal with it. Having known what it is, tell the examiner that it is an action upon the case because it requires proof of damage. For the plaintiff to succeed in an action under the rule in Wilkinson versus Downton, the courts have held the view that the plaintiff must prove that the defendant engaged in a deliberate act or willful act or misrepresentation. That deliberate act or willful act or misrepresentation was calculated to cause harm to the plaintiff. Now, nobody will say that I intended to cause harm to you. They will tell you it was a prank. But you know that as a basic principle of the law, a man intends the natural and probable consequences of his actions. And so you must be guided and you must pay attention. And then the last element is that it must actually cause harm to the plaintiff because it is an action upon the case. In Wilkinson versus Downton, the defendant called the woman and told her that her husband has been involved in an accident and the husband requires that he comes immediately to pick him up. The woman suffered nervous shock and sued as a result. The court said that there was liability. There was liability. There was liability. The court held that there was liability. Now I need you to note that here there is liability. And I mean, there must be proof of damage. There must be proof of damage. So you must pay attention and you must be guided. And then we can talk about the case. And so in Wilkinson and Downton, the court said that there was liability. We can talk about the case of Janvier versus Sweeney to support the case of Wilkinson versus Downton, where you will get to realize that in Janvier versus Sweeney, they went ahead, sought to tell the maid that if she doesn't allow them to read the mistress's letter, the mistress, they would deport the boyfriend. The maid suffered some damage as a result, and then the court took the view that there was liability. Under Wilkinson and Downton, or the rule in Wilkinson and Downton, you can also note that sometimes it will deal with unwanted phone calls. The girl says it's over, don't call me again. You are pestering the girl with unwanted phone calls. The requirement of the law is that so long as that person can prove that they have suffered some damage, there will be liability. Bennett versus George contrasted with the case of Khorasanjan versus Bush. The requirement is that you must prove that you have suffered some damage. Pay attention. The area of law, the topic is not Wilkinson versus Downton. The topic is the rule in Wilkinson versus Downton. The rule in Wilkinson versus if you say area of law, Wilkinson and Downton, a case. Wilkinson and Downton, a case, and area of law. It is a case. So the area of law is the rule in Wilkinson versus Downton. We close the chapter on the rule in Wilkinson versus Downton, and then we can go to what we call trespass to land or intentional interference with property. Trespass to land or intentional interference with property. If this may help you in any way, trespass to land has all the elements of battery, all of it. Same elements, same principles, but the cases will differ. If you are citing an authority under trespass to land, and you go and cite Scott and Shepherd, you are gone, irredeemably gone. Because how can Scott and Shepherd be trespass to land? Because my lady Abrefi said that it deals with all the same element. Mr. Cases need the differ. One deals with land, the other deals with person, but the principles are the same. And so you can lay your foundation under Article 18 of the 1992 Constitution. It secures a person's ability to own a property. Article 18.2 will add that there must be privacy. You enjoy your privacy. It is on this basis that where the defendant, through his direct and voluntary act, either intentionally or negligently causes physical interference with the land of the plaintiff, that will amount to trespass to land without that plaintiff's consent. So where the defendant, through his direct and voluntary act, either intentionally or negligently causes physical interference with the land of the plaintiff without that plaintiff's consent, there will be liability. Trespass to land is actionable per se. it is actionable per se. What it means is that the plaintiff need not prove damages to succeed in that particular action. But for the plaintiff to succeed in an action under trespass to land, he must prove 6 major elements, and they are direct act, voluntary act, state of mind, physical contact, and then lack of consent, and then positive act. Direct act, voluntary act, state of mind, positive act, physical contact, and then or physical interference, and lack of consent. The very first element is to the effect that it must be the direct act of the defendant that brought about the physical interference with the land of the plaintiff. One thing I need you to note is that in respect of, stating the point, you don't just say firstly direct act. No, state it in a sentence form. It must be the direct act of the defendant that brought about the physical interference with the land of the plaintiff. This requires that the principle of the law is that it must be the immediate act of the defendant that brought about the physical interference with the land of the plaintiff. And this was held in the case of Pickering versus Rood. The second element that the courts have held is the element of voluntary act, which of course deals with controllability. He who is in control of the person or the instrument that caused the physical interference is the one that should be liable under the tort of assault. So it deals with controllability. Who was in control of the person? The case of Smith versus Stone. Smith versus Stone. The particular defendant was carried onto the land of the plaintiff. The court said that at the moment or at the material time, the defendant was not in control of himself. But if there should be anybody to be liable, it must be the third parties who carried him onto that particular land. Voluntary act vitiated. And then the third element is that there must be the required state of mind. The law is that the defendants must have acted either intentionally or negligently for the action to succeed. Where intention is vitiated and negligence is also vitiated, the action stands to fail. Again, Smith versus Stone. The man didn't have any intention, neither did he act negligently. But you can look at the case of Beasley versus Clarkson, which also supports voluntary act. In fact, in Beasley versus Clarkson, the court held that there was liability for trespass to land. What it means is that all the elements under trespass to land were established. So you can use any of them. So in Beasley versus Clarkson, the defendant was mowing his lawn, and owing to an ill-defined boundary, he mowed the lawn of the defendant, the plaintiff. The court said that there was the element of negligence, there was the element of voluntary act. It was his direct act. Of course, when we are talking about positive act, that the defendant must have engaged in some positive act, it means that the defendant must have engaged in some overt act. Generally speaking, omission to act constitutes no trespass. Not doing is not trespass. You must have engaged in some overt act for there to be liability. This is the position of the law. This is the requirement of the law. And so you must be guided. Now, the next thing I need you to note under positive act is that in Beasley versus Clarkson, of course, he mowed the lawn. And then you come to the last but one element, which is physical contact or physical interference. The law requires that there must have been some physical interference with the land of the plaintiff, such as the defendant being on the land, staying on the land, or throwing an item onto the land, or throwing an item onto the land. There must be physical interference. The requirement of the law is that where there is no physical interference, the action will fail. Now, you can use the case of Lavender versus Betts. The plaintiff is a statutory tenant, the defendant is his landlord. The defendant, under the guise of going to have a conversation with the plaintiff's wife, ordered some macho men to remove the doors and the windows, where he was actually, as it were, in the presence or in the room of the plaintiff. The court said that because there was physical interference, there was liability. Now, someone may be asking, how can a tenant sue the landlord and succeed? I will answer that question briefly, so pay attention and hold on. Then the last element, and in Lavender versus Betts, you can contrast it with the case of Pereira versus Vandia, where statutory tenant, but the landlord says, I will not come to your house. I will sit in my own house and cut out the electricity and the gas supply. The court took the view that because there was no physical, contact, or physical interference, there can be no liability. The last element is lack of consent. Now, some of you, when you are getting married, invite me, I will come. The point I'm trying to establish is that if you are getting married and you don't do it strictly by invitation, living legends, we will also show up because of wedding jollof and wedding chicken. So long as you have consented that we be on the land, we do not become trespassers. We can only become a trespasser where you have revoked the consent, and in defiance of the revocation, we continue to be on the land. Now, the principle I'm trying to establish is that he who consents to a thing cannot complain of trespass. What it means is that if the plaintiff has consented that the defendant be on the land, to the extent that that consent is still in force, the defendant becomes no trespasser. But the defendant will become a trespasser where the consent has been revoked and the defendant continues to be on the land. And this was held in the case of Hearst versus Picture Theatres Limited. The court took the view that where the plaintiff consents for the defendant to be on the land, he becomes no trespasser. That plaintiff will only be a trespasser where the defendant will be a trespasser if the plaintiff has revoked the consent, and in defiance of the revocation, the defendant continues to be on the land. Wakosra oge osiwanu wejai. First ne de nka akwa nka ma wrem, but se de osiwanu wejai nto ma unra dem hobio. Don't continue to be on the land. Gentlemen, break up. Go home. Go home. That is just by the way. So long as you continue to be on the land, there will be liability if the consent has been revoked. But if the consent has not been revoked, then there will be no liability. Now, I want you to note this principle in respect of who may sue. When it comes to trespass to land, the law does not necessarily protect ownership. It protects possession. He who is in possession. That is why in Lavender versus Betts, a tenant was able to sue the landlord. In Lavender versus Betts, a tenant was able to sue the landlord because trespass to land does not necessarily protect ownership per se. It protects persons who are in possession. He who is in possession. And when you look at cases like Brown versus Kwashiga, Wuta Ofe versus Dankwa, the courts have defined possession to mean corpus possessionis and animus possidendi. Corpus possessionis means actual physical possession, whilst animus possidendi means where you are not actually physically present, but you exercise an intention to possess. So you may not be physically present, but you are paying the land rate, you are paying the this, you are paying the that, exercising an intention not to possess. So you see what kwawari ebisa. Sanso na wokoto dan ebisa. Wokoto dan ebisa. Na dan na wokoto no, ye di pila agye ho ahia. Ana mo ka che say ya hyeda na ye di agye woboa wo daadaa o. E obi dan. E obi asase. Nipa wo so, because physical possession can be through planting certain things on the land. Planting certain things on the land. So you must pay particular attention. So it does not protect ownership per se, it protects persons in possession. And he who sues under trespass to land may be suing for damages, injunction, or recovery of land or recovery of title. And he who is sued under trespass to land in respect of the defenses may raise the defenses of consent, inevitable accident, as it were, abatement of nuisance. We will discuss these elements again when we are dealing with general defenses. You close the chapter on trespass to land. I hope I can proceed. My lady moderator, please, I hope I can proceed. Hello?
Yes, my lady, please proceed.
All right. All right. Now, let's look at Let's look at trespass to chattel, trespass to chattel, trespass to, and here we are dealing with the circle boys, the kwashe boys, the kwashe boys. They will kwashe your phone right now. We are going to treat them under trespass to chattel. Dealing with the chattel of another or intentional interference with the chattel of another without that other person's consent. Intentional interference with the chattel of another without that other person's consent. Now note that whilst trespass to land deals with landed property, and I'm not taking you through land law, but when you look at section 281 of Act 1036, it defines land to include the surface soil, the things naturally and artificially affixed to the land, interest or right that can be held in the land, and then things beneath within the reasonable airspace, and that is what that the trespass to land deals with. But trespass to chattel deals with immovable properties, goods. You have gone to collect the wig of your friend for graduation. Submit the wig, deliver the wig, deliver the wig. They call you, you say, I will bring it, I will bring it. You don't bring the wig. Those are the kind of situations we are going to deal with under trespass to chattel. Now, my time last 2 years, we got a situation where somebody treed the car. Don't write treed the car on the paper. Treed the car of the defendant. Scratching. So he treed the car of the defendant, and then you are raising your thought of trespass to chattel. Now, the point we are dealing with under trespass to chattel, when you look at the case of Folds versus Willoughby, the court defined it as the intentional interference with the chattel of another. And in Folds versus Willoughby, the court indicated that the slightest interference with the chattel of another constitutes an actionable tort, which is under trespass to chattel. Again, it must be done intentionally, there must be direct act, and all the other elements we have spoken about. But note that in Ward versus Makola, the court took the view that trespass to chattel protects persons in possession. I may not have a laptop. If I am to defend my thesis, University of Ghana master's program, if I am to defend my thesis and I go for my neighbor's laptop and I'm using it, within that period, if someone touches it or interferes with it, I have the capacity to be able to sue. So trespass to chattel deals with persons in possession. Ward versus Makola. I need you to note and I need you to pay attention that he who chooses to sue under trespass to chattel may either sue under conversion or under detinue, depending on the nature of the set of facts and the remedies your client is seeking for. If your remedy says, me here nisi kan fanya she, me here me wig nana me here bone straight, and one me here, you cannot go under conversion because conversion will only afford you damages. So we are going to do a contra distinction between the two. Then we would look at the advantages of one over the other, and then the disadvantages of one over the other, so that when you get a fact pattern, you will choose how best you can represent your client. And so when you look at conversion, some people say it is the civil version of stealing. Don't write it anywhere. In as much as it will help you to understand conversion, it is not a good thing to write on paper, at least you can say. So the point we are dealing with under conversion, the case of Standard Chartered Bank Ghana Limited versus Nelson, the court took the view that when you are dealing with conversion, or when we talk about conversion, it is the dealing with the chattel of another in a way that is contrary to the right to use and enjoyment of that other person's rights, coupled with exhibiting an intention not to allow that other person to use that property in that accord. Dealing with the chattel in a way that is contrary to the right to use and enjoyment of that person, coupled with exhibiting an intention to deny him of the right to use and enjoyment thereof. Let me give you an example. Circle. You are passing through Circle and you are now doing Zoom call. They will kwashe the phone. Now, when they kwashe the phone, that person that kwashed the phone, that person has dealt with your chattel, and that is the phone, in a way that is contrary to the right to use and enjoyment of your phone. Now, normally when they kwashe it like that, within the next 5 minutes, if you are searching for the phone, you will find it within the environs of Adabraka. But I am very familiar with that particular situation. You will find it around Adabraka, or 20 Ghana, iPhone 14 Pro Max, 17 Ghana, or the kodidi. So the point I'm trying to establish is that in doing that, they would have dealt with it in a way that is contrary to your right to use and enjoyment of it. And there will be exhibition of an intention to deny you in the use of it. So in Standard Chartered Bank Limited versus Nelson, the court said that the elements to prove under trespass to under conversion will be that there must be dealing with the chattel in a way that is contrary to the right to use and enjoyment of that particular person's right. And dealing with it, the court took the view that it means wrongfully taking it, wrongfully disposing it of, or wrongfully detaining the chattel. And the second element is that there must be exhibition of intention to execute it. Now let's know the nature of detinue, which was also distinguished in Standard Chartered Bank versus Nelson. Then we will do a contra distinction between the two. When we look at detinue, it is the wrongful detention of the chattel. Abusia wig no okwa je no okwa sreye ene ye de wig ne ma wo so de fa koye graduation. Na wo wie graduation na wo de aba. Why graduation awie, what your first class awie, when your first job am you wedi, why apply for second one, wig no one for my. So you got the thing lawfully, but the detinue lies in the wrongful detention of the thing. Detinue lies in the wrongful detention of the chattel. So the principle of the law is that when we speak of detinue, we are talking about the wrongful detention of the chattel, which upon express demand for it, there has been refusal to submit it. So once there is detention of the chattel, you may have come across it lawfully. You may have taken it lawfully. Obi de ne ba bejawa emedane oba. So what the baby jaws me the mebani ko school na upon school man met na wenche and you mra be funny ba so man funny banko. A ba is not a chattel. I'm using it for you to understand. I feel the opposite say ba ne ya oba ya nyu obi ba mososa. The point is that you must not wrongfully detain the chattel of another person. So that is the point we are trying to establish. So it lies in the wrongful detention of it. So some people will say that where conversion will lie, detinue can also lie. You must pay attention because it lies in the wrongful detention of it. Now, there must be detention of the thing, there must be demand for it, there must be refusal to deliver upon the demand. This is the nature of detinue. Now, let's look at the contra distinction between conversion and detinue, which will instruct you to, as a top-notch lawyer, Mensa Saba Award winner, Chachuchikata of our time, it will instruct you to actually determine which one you want to sue under. Now, by virtue of the contra distinction, you would realize that conversion acts in personam. What it means is that conversion goes against the tortfeasor, but detinue acts in rem. It means that detinue goes against the property. It goes on to say, therefore, that where the property has left the custody of the tortfeasor, the party who is responsible for the conversion or the innocent party can no longer recover. And to a kwashe fono no okoton dia wuji. But under detinue, because it goes after the property, wherever the property is in this world, you will be able to recover it. That is what we mean when we say it acts in personam and one acts in rem. And then another difference between the two is that under conversion, the court is likely to award damages only under conversion in the form of monetary compensation. Something small to take home. But under detinue, in addition to damages, the court may award specific delivery of the item, or the court may award assessment of the value of the item. So you must pay particular attention and you must be guided. That is another distinction between conversion and detinue. And then another distinction also is that under conversion, damages are assessed at the time of the conversion, whereas under detinue, damages are assessed at the time of judgment. Based on these contra distinction, we can look at the advantages of detinue over conversion. And one of them is that because detinue acts in rem, even when the property has left the custody of the tortfeasor, you can still recover it. That makes it an advantage over conversion. And then another one is that detinue affords several other remedies apart from damages. The person may not need monetary compensation for anything. The person needs the chattel. Mumu bi wɔ ha na sɛ yɛmu bi wɔ ha yɛfo yira asɛm ɛbɛba no nyasɛm kotoa, because the documents on the phone and the things on the phone alone is enough to save an entire generation. So please pay attention. And so detinue affords several other remedies, such as assessment of the value, and then also the asset where the payment of or specific delivery of the item. And then finally, in respect of the advantages, because judgment is assessed at the time of, damages are assessed at the time of the judgment, it is better to sue under detinue when the chattel is one that appreciates with time. If it appreciates with time, it is better to sue under detinue than to sue under conversion. The only advantage of conversion over detinue, of course, res ipsa loquitur, the matter will be speaking for itself, is that where the chattel depreciates with time, then it is better to sue under conversion than to sue under detinue. You must pay attention, and you must be able to draw these lines between the two, because your ability to draw the lines between the two is what will influence you as a top-notch lawyer, Mensa Saba award winner and Chachuchikata of our time, to be able to validly advise your clients. To be able to validly advise your clients. Or clients about, and the set of facts says that he needs the iPhone back. He needs the iPhone back. If you go and say that I will see you under conversion, you better sisika near the amount as it were. You better sisikana ya the amount of clients, But because she says she needs the iPhone back, you may want to go under detinue. You must pay particular attention, and this is where we close the chapter on to conversion and detinue, and then trespass to chattel. You must pay particular attention. With the permission of the House, I will move on to intentional interference, that the defenses, what we call general defenses, in defenses to intentional interference with, intentional interference to persons and property, defenses, general defenses under tort law. Now, I need you to note that defenses are factors that will either exonerate a person completely from liability or partially from liability. What it means is that it can be a complete defense or a partial defense. Now, let's go into them. The very first one I need you to note is the defense of consent. Of course, as notorious as it is, you can find it literally everywhere. He who consents to a thing cannot complain of trespass unless that consent is vitiated by an element such as fraud or anything. Unless the consent is... Hey, tetenete. Hey, my Lord Tetenete. Please mute yourself. Good. Now, the point we are trying to establish is that in respect of consent, it must not be vitiated by any vitiating factor. It must not be vitiated by any vitiating factor, such as fraud or anything. The point is that he who consents to a thing cannot complain of trespass. And here you have the case of Hegarty versus Shine. Boyfriend, girlfriend who have dated for no less than 2 years. They were doing the do. They were having sex, intercourse, sexual intercourse every day. Hey, I wasn't there, but they were having sexual intercourse. Now, the girlfriend noticed that she has contracted a venereal disease in its communicable form. That is to say that what the A Safano. So the point is that the girlfriend sued for what is the doing the do. They were doing the do. So So the girlfriend sued for trespass, and the court said that when you receive the Holy Spirit, you receive Jesus and God, the Trinity as a whole. They didn't state it in the rules, but I'm telling you. They said that when you receive Christ, you receive the Holy Spirit and God in its entirety. If you have consented to the sexual intercourse and you were enjoying yourself, all the things that come with the sexual intercourse, you have consented to it. there was consent. Note that consent is a complete defense. Consent suffices as a complete defense. So it will completely exonerate you from liability. And then we have inevitable accident. Inevitable accident. There are certain situations where even reasonable caution cannot provide against them. So even reasonable caution cannot provide against them. So some of these things, we call them inevitable accidents. If it was not done intentionally or negligently, then it is inevitable accident. Fowler versus Lanin, Stanley versus Powell. You can have self-defense, and self-defense is where you use reasonable force to prevent a tort from being committed against your personal person. Self-defense. Reasonable force is what is required. Reasonable force is what is required. When you use reasonable force to prevent a tort from being committed against you, it is a self-defense. It is a complete defense, and it can actually, exonerate you completely from liability. It can exonerate you completely from liability. I need you to note that Asante versus the Republic, police because the court said that he was using reasonable force to resist unlawful arrest. Asante versus the Republic. And you can use the case of Cockcroft versus Smith, where the lawyer and the clerk was fighting, and the clerk pointed the finger at the lawyer, and he bit it off. Wakan in summary, he bit it off. The court took the view that the force that the lawyer used was an unreasonable force. There was liability. So self-defense. You can also have the defense of another person. Defense of another person. Defense of another person. Sometimes you may not be defending your own self, but you may be defending another person. That is also a complete defense. The case of Hancock versus Baker. They stopped the man from murdering his wife, and he got the guts to go and sue for false imprisonment and then trespass. The court said that defense of another person constitutes a complete defense. And then you can look at another defense, which is defense of another person's property or defense of one's property. When you are defending your personal property, a property that is in your custody, kano. Or yes, obey we are phone as son in some circle. Kano, no enjoy phone in mouth, nafako. Or casobe shimo phone and nasa utimi son in some say kuchre. Kano mehontu. That is defending your property. That is the point I'm trying to establish. Bird versus Holdbrook. The courts have taken the view that if you were using reasonable force to defend your property, that is an actionable, or it suffices as a complete defense. And then you can have the defense of necessity. Odifo Jonah, defense of necessity. When they were on the high seas and the storm were raging, and they needed to put something inside the sea so that the storm will stop raging, Odifo Jonah, they picked him from the ship into the sea. And yes, Okotobo Nsuyem. That is the mouse's case. That is the mouse's case. The storm was raging, and so they picked some items and then threw it into the sea. When he sued for trespass to chattel, the court took the view that no, it was necessary to save the mass or to save the general public. And then you can have the defense of discipline. The defense of discipline. The defense of discipline. Shabofra ne kwan a wonfa so na wonyina wonfiri ho na me se wa wonim na abakwa kwatworo twi wo script ne so shabofra ne kwan a wonfa so na wonyina wonfiri ho to wait no atworo to wait. Teach the child the way he should go so that she will not depart from it when she grows up. What do you say? You are lying. The language of the law is English, but we want to understand the law, so we use the tree to be able to understand it. That is the point we are trying to establish. So discipline is where you use reasonable force to actually teach or train up a child or a person who you are standing in loco parentis with. The case of Ash and Ash, the courts have taken the view that in respect of discipline, the force used must be reasonable. It must be proportionate in the circumstance. And yes, a discipline, your friend discipline, ash and ash, the force must be reasonable and it must be proportionate in the circumstances. Ryan versus Fields and another. Ryan versus Fields and another. The court took the view that the teacher punched the ear of the child and the child became deaf in that ear. The position of the law was that constituted unreasonable fear or unreasonable force. Please, those that do not understand tree, whatever it is that I say in tree, I try to interpret it in English so you are not losing out or you are not missing out. So that is the defense of discipline. And then you can have contributory negligence. I always say this to the people that I meet, that contributory negligence is a partial defense. And the essence is, Mama, and I'm way, but me kebi ma kwabna. And two babo me fifa, bo me tre, na bo kwabna too. What it means is that the defendant is admitting liability, but he is saying or making a counterclaim that the plaintiff has also contributed to the harm or the seriousness of the harm in a certain way. And so the plaintiff will also be liable to some extent. The case of Jackson versus O'Connell, the plaintiff failed to wear the helmet. The court computed his contribution at 15%. Owens versus Brimell, the plaintiff actually went on a drinking spree with the defendant and still failed to put on seatbelt when they were driving. The court contributed or the court considered his liability to be around 20%. So that is the point we are trying to establish. These are the general defenses. Now, what I need you to note is that it is not exhaustive. Abusia, it is not exhaustive, but at least they are the general defenses that we can speak of. Someone may speak of voluntary unfit injuria, but it comes under consent. Voluntary assumption of risk. It comes under consent. Jackson versus O'Connell. Jackson versus O'Connell. Ladies and gentlemen, for purposes of our preparation towards the entrance exam, I need to introduce you to the next topic, which is actually private nuisance. Private nuisance. It deals with all forms of situation which causes you annoyance, discomfort, or inconvenience. Those are the kind of situations we are dealing with. When you see car bobresi dying, we see dining we ya no abusu afọ kan obi akoma afi no be start pote pub e wo dan nachi eda we see dining we went me anam anya ni je da nuisance. Private nuisance. Now private nuisance protects persons who have proprietary interest in the subject matter from the use of or the unreasonable use of the defendant's land, which causes them annoyance, discomfort, or inconvenience. When we speak of private nuisance, we are talking about a situation where the plaintiff is alleging that the defendant has put his land into an unreasonable use, and such unreasonable use causes him annoyance, discomfort, or inconvenience. That is the position of the law. Now, I need you to note that for the plaintiff to succeed in an action under private nuisance, he must prove three major elements. The very first one is that the plaintiff has a proprietary interest in the subject matter. The law requires that you must have a proprietary interest in the subject matter to be able to succeed in an action under private nuisance. And so this answers the question of who may sue. In respect of who may sue, we are dealing with persons who have proprietary interest in the subject matter. And when you look at section 1 of Act 1036, the various interests that can be held in land have been captured there. So you will be fine. Now, you must have a proprietary interest in the subject matter, and this was held in the case of Maloney versus Lasky, Hunter versus Canary Wharf. You must have proprietary interest in the subject matter. So it goes on to say, therefore, that a patcher, a lodger, who patch, who claim nuisance, who patch claiming nuisance, who was something a difference, because the law does not protect such persons. You must have proprietary interest in the subject matter. You must have proprietary interest in the subject matter. Maloney versus Lasky, Hunter versus Canary Wharf. The second element is that the defendant must have put his land into an unreasonable use. And what constitutes unreasonable use may differ from place to place and from time to time. Now, what may be reasonable at East Legon Hills may not be reasonable at Nima Mamobi, where we are. We understand ourselves. East Legon Hills, you can use 1 acre to plant flowers. Don't do that, Nima Mamobi. It's a caution that I'm giving. So the point we are trying to establish is that in determining what constitutes reasonableness, the courts are guided by certain factors. So there are 4 major factors that the courts are guided by in determining what constitutes reasonableness or otherwise. The very first one is the suitability of the locality. Certain areas are demarcated for certain peculiar purpose, and so the court will consider whether what you are doing is suitable. If it is not, then it must be established that it is nuisance or it is unreasonable. Edu versus AJ, to pound or to operate a chopper in a residential area amounts to private nuisance. Thompson Schwab, and this is the case that students like, I don't know why, but Thompson Schwab versus Kostaki, to engage in prostitution in a residential area amounts to private nuisance. Ball versus Ray, to rear horses in a residential area amounts to private nuisance. You must note these cases. And the second factor is the purpose of the defendant's conduct. What is the purpose of the defendant's conduct? If the purpose is to cause annoyance, discomfort, or inconvenience to the other party, then there will be liability. You can look at the case of Christie versus Lichinsky. A shower case near Thompson Schwab versus Kostaki. Then you can, for the purpose, Christie versus Lichinsky. The plaintiff was engaging in musical lessons. The defendant was hitting on Trace unnecessarily. The court took the view that the purpose of it was actually to cause annoyance to the particular plaintiff. And then we have the third factor, which is sensitivity of the claimant. Fana is yogurt. Fana is yogurt. Yes, Fana is yogurt. You are claiming allergy. Fana is yogurt. You are claiming allergy because you are overly sensitive. What if you are overly sensitive? Then the matter will not constitute an unreasonable use of the land. So it's untima womunya aure enyumre aure na ye che niema no wunti ma ye nya aure because they den wuntimi na. So being overly sensitive, what they are doing will not be constituting private nuisance. And here you can have the case of Kilvert versus Robinson. Kilvert versus Robinson, the court said that the paper is actually sensitive to heat. That is why it is turning brown. Not that what the company of the plaintiff is actually a nuisance. And then finally, we have duration or timing of the nuisance. What will constitute nuisance in the morning may not constitute nuisance in the night. What will constitute nuisance in the night may not constitute nuisance in the morning. You must be guided. CFC Construction Limited versus Accra Tema City Council. They were dumping refuse on the land, emitting pestilential smell. Note that if it is for a longer duration, it will amount to private nuisance. Halsey versus Esso Petroleum. Filling gas, if it is during the day, no nuisance, but during the night, it will amount to nuisance. These are the factors that the court will use to determine the unreasonableness of the particular asset where conduct. And then the third element is that it must cause the defendant, the plaintiff, annoyance, discomfort, or inconvenience. What it means is that the damage that the plaintiff must be able to prove is that it causes him annoyance, discomfort, or inconvenience. Now, having determined this and the elements, one of the major things you need to note under private nuisance is the defenses. In respect of the defenses, you can have the defense of prescription. The defense of prescription, and your doctor's prescription, I'm talking about prescription in the eyes of the law, where it is to the effect that if the defendant has engaged in that particular conduct for a continuous period of no less than 20 years, openly, without secrecy, without force, or without permission, then he gains the common law right of engaging in that act. So the defense of prescription means that, my Lord, Mr. Wada, Adia Waka Wasemi, my in fear 45 years. I've been doing this thing for 45 years. Neniso ya again. Wohubi na meye sadieno. Afedi wo claiming allergy, my Lord. I am relying on the defense of prescription. I have done the thing openly, freely, without secrecy or without permission for a continuous period of no less than 20 years. Then the person gains the right. But when you look at the case of Sturgis versus Bridgman, the courts have taken the view that the 20-year period begins to count from the moment where the plaintiff came to the nuisance or became aware of the nuisance. So pay attention. Sometimes they will give you a set of facts, and the person started doing the thing 92 years ago, but the plaintiff came to the place 7 years ago. The 20 years period has not elapsed, because the 20 years begin to count from the period that the plaintiff became aware of that particular nuisance. You can also have the defense of consent. You can have the defense of statutory authority, and then abatement of nuisance. He who sues under nuisance may be seeking certain remedies such as damages, injunction, or abatement, and order for abatement of nuisance. We close the chapter on private nuisance, and then we can move on to the rule in Rylands versus Fletcher. The rule in Rylands versus Fletcher. Again, the topic is not Rylands versus Fletcher. The topic is the rule in Rylands versus Fletcher. Abusia, what the idea about wasase so na say free wasase so cause harm to somebody, there is liability. The rule in Rylands and Fletcher deals with situations where the defendant, puts his land into a non-natural use, and in putting the land into a non-natural use, he brings onto the land or causes to be brought, accumulated onto the land, a thing which has the tendency of causing danger when it escapes, and it causes danger when it actually escapes. The rule in Rylands and Fletcher deals with a situation where the defendant, in putting his land into a non-natural use, brings or accumulates or causes to be accumulated a thing onto that particular land, which that thing has the tendency of causing danger when it escapes, and it actually causes danger when it escapes, or by virtue of its escape. So the rule in Rylands and Fletcher, and the plaintiff suffers some damage as a result. I mean, the danger is what the plaintiff will suffer. The rule in Rylands and Fletcher is an action upon the case because it requires the proof of damage. Now, in respect of the elements of under the rule in Rylands and Fletcher, the courts have taken the view that for the plaintiff to succeed under this rule, he must be able to prove 5 major elements. The first element is that the defendant has put his land into a non-natural use. And I will take them one after the other and explain them. The defendant has put his land into a non-natural use. In Rylands versus Lothian, the court said that putting your land into a non-natural use means that you have put your land into a special use, which brings with it increased danger. It is not the ordinary use of the land. It is not the customary use of the land. It is a special use which brings with it increased danger. This is the position of the law in Rylands versus Lothian. And so in Rylands versus Lothian, the court said that when the defendant brought normal water to his residential apartment, that was not a non-natural use of the land. But in Rylands versus Fletcher, the court took the view that bringing the reservoir onto the land for the purpose of getting more water constituted a non-natural use of the land. The second element is the element of accumulation. The position of the law is that the defendant must have accumulated the thing onto the land, or he must have caused to be accumulated the thing onto the land. What this means is that he either brought the thing himself or he was responsible for the bringing of the thing. If you look at Rylands and Fletcher, they didn't bring it themselves, but they contracted independent contractors to bring the reservoir. That is also accumulation. But in Dublin versus Ghana Housing Corporation, where the court took the view that the heavy rainfall is what caused the escape and then what caused the harm, heavy rainfall is something that people do not have control over. It was an act of God, and so there was no accumulation. The third element is that there must be a thing. Now, the law is that this thing need not be dangerous in itself, but it must have the tendency of causing danger when it escapes. So it can be anything at all, but it need not be dangerous in itself. It must have the tendency of causing danger when it escapes. And so a thing can be anything. In Rylands and Fletcher, the thing was the reservoir. It can be anything at all. The fourth element, which happens to be the bone of contention, is the escape of that thing. No escape, no liability. No escape, no liability. And escape in law means that it must have left the custody of the defendant. It must have gone outside the custody of the defendant. That is what we mean when we speak of escape of the thing. Rylands and Fletcher, the water left the custody of the defendants and caused harm to the minds of the plaintiff. But when you look at the case of Ponting versus Noax, the defendant had planted a yew tree in his house, and the plaintiff's horse stretched its neck to eat of the yew tree and died. The court said that the yew tree did not escape. It was rather the horse that even caused trespass. So there was no liability. And then Reed versus Leon, where there was an explosion inside the factory, the court said there was no escape. There was no escape. But okay, Apiache. They said there's a place called Apiache. The place that's in Ghana here, that there was explosion, that the whole community was wiped off. Apiache. Maybe I'm not pronouncing it well, but Apiache. You people remember that situation. There was an escape. Apiache. Apiache. So there was an escape. There was an escape of the thing. So there must be escape. There must be escape. And then the last element is that that escape must have caused danger to the plaintiff. Of course, it is an action upon the case. And so the damage may be to your body, to your person, or to your property. Saville versus Roberts, the CJ Holt made this profound statement. Now, under the rule in Rylands and Fletcher, there are some cases or some defenses that you must note. The very first one is an act of God. It is a complete defense, act of God, what some people call force majeure. June, something. What happened at Circle? In Suonetoye, act of God, act of God. That is the point we are talking about. And then, so there you can use the case of Dublin versus Ghana Housing Corporation. And then you can also talk about act of a third party, where a third party maliciously causes the escape. The defendant will not be liable. Rylands versus Lothian. We know that it was the third party that entered the room and opened the taps and blocked the exit points. The court said there will be no liability. There can also be consent, and there can also be statutory authority. He who sues under Rylands and Fletcher can also sue for injunction, damages, among others. We close the chapter on the rule in Rylands and Fletcher. Let me draw your attention to the fact that the topic is not Rylands and Fletcher. The topic is the rule in Rylands and Fletcher. The same way the topic is not Rylands and Wilkinson and Downton. It is the rule in Wilkinson versus Downton. That is the point we are trying to establish. Let's deal with economic tort as the next topic. The economic torts as the next topic. Economic torts as the next topic. Now, when you look at Article 24 of the 1992 Constitution, it secures a person's ability to work. If you are able to work, then it means that you must be able to earn a living. Economic tort is a collection, or cumulatively, it protects persons' right to earn a living. Yay. MCF 11, Doreen. Please be guided. Doreen, all right. So the point we are trying to establish is that economic tort protects persons' right to earn a living. It protects a person's right to earn a living. And it can be of different types. And so we are going to look at all those types, and then we'll look at what the law says about it. You may have passing off. You may have, intentional interference with contractual relations. You may have as it were, injurious or malicious falsehood. You may have intimidation and then conspiracy. Among others, they may not be exhaustive, but I'm going to deal with these ones. Now, when we talk of passing off, we are talking about a situation where the defendant, by a misrepresentation, makes the public believe that the goods and services of the defendant are the goods and services of the plaintiff. So it deals with situations where the defendant makes a false representation to the public, likely to induce them to believe that the goods and services of the defendant are the goods and services of the plaintiff. So what we mean to say is that Adidas, unim se wakoto Adidas o, abusia bronya bre, unim se wakoto Adidas, ubaba bedru fie na ye Abibas, Adidos, Adibos, it's okay. Now some of the Apple phones, Apple no, abuane ka ne mfe, wanka soro no, waka ne mfe, eye fake. But the people are making you believe that the goods and services of the defendant are the goods and services of the plaintiff. That is what we are talking about. Passing off. Where so somebody is operating and using A1 bread or A1 bread. Then you start bread production factory and then you say A2. Nike ne Mike. Akɔ ne kurom akɔka kyerɛ ne kuromfoɔ sɛ nnɛ makoto sneakers sɛ watɔ Mike sɛ watɔ kwabena Mike no watɔ abɛfie ɛna wɔde tene sɛ wakoto sneakers wohyɛ ne kurom enye ye. Let's pay particular attention. Those are that particular kind of situations that we are dealing with. Passing off. Now I need you to note that passing off will only exist, and in respect of the elements, passing off exists where the defendant, there is reputation attached to the product of the plaintiff. There must be reputation or goodwill attached to your product. There must be goodwill or reputation attached to your product. And yes, our customers, year 6 now we will sue for passing off. We are not dealing with underground business owners. We are dealing with those that have goodwill or, reputation attached to it. And the defendant must have made a false representation to the public. Thirdly, that false representation must have been intended to induce the public to believe that the goods and services of the defendants are the goods and services of the plaintiff. And the public must actually be induced into so believing that the goods and services of the defendants are the goods and services of the plaintiff. And then also, the plaintiff must suffer some damage as a result. That is being denied of his right to earn a living. These are the elements to prove to succeed under passing off. And the very famous case of Redaway versus Barnum. He was operating a belting company and naming his products camel hair belting. But the defendant started similar production and named his camel hair beltings. The court said it was passing off. You can also rely on the case of White Hudson versus Asian Organization, where they were producing hacks toffees, and someone is calling his petco pecos, another is calling his hacks. But the court said that because they were all using orange wrappers, it was likely to mislead the public. That is the essence of passing off. And then you come to intentional interference with contractual relations, where the defendant has knowledge that there is a valid contract existing between the plaintiff and a third party, and that defendant intentionally interferes with that existing contract such that the person is unable to perform. To succeed under intentional interference with contractual relations, the law is that there must be a valid contractual relationship between the plaintiff and a third party. The defendant must be aware, he must have knowledge of this valid contractual relationship, and that knowledge can be actual knowledge or imputed knowledge. And then he must have intentionally interfered with it. The case of Lamley versus the opera singer, the uncle knew that there was a contract, but he intentionally interfered with it, denying the plaintiff of his right to earn a living. Now, you can have, the defense of justification. Somebody can reasonably or justifiably interfere. The law will permit that. And then we can have injurious or malicious falsehood. Now, pay particular attention because the terms of injurious or malicious falsehood may be similar to that of defamation. It may be similar to that of defamation. The elements for intentional interference is that there must be a valid contract. This must be to the knowledge of the defendant. He must have intentionally interfered, and the plaintiff must have suffered some damage as a result. In terms of injurious or malicious falsehood, it may be similar to that of defamation, but the distinction is that injurious or malicious falsehood deals with the business of a person. So the position of the law is that if the defendant publishes a statement capable of having defamatory meaning, and it is actually defamatory, and it is made in reference to the business of the plaintiff, and the plaintiff suffers some damage as a result of the publication, what it means is that it must have been published by the defendant, and he suffers some damage as a result, there will be liability. Now, I need you to note that it is in relation to the business of a plaintiff. Now, say airport, yet say for be restaurant be those things, if it happens to be untrue, then it means that it brings the reputation of the business down. That is injurious or malicious falsehood. Radcliffe versus Evans, the defendant went about telling the public that the business of the plaintiff was not in existence when it actually was. There was liability. And then you come to intimidation, where a person uses force or threat to deny another person of his right to earn a living. And then conspiracy, where two or more persons agree to act together with the common purpose of denying a person of his right to earn a living. This is it for economic tort. You must be guided. The very notorious ones amongst them is passing off, intentional interference with contractual relations, and injurious or malicious falsehood. You must pay attention. Our next topic is general negligence. Our next topic, general negligence. Now, I need you to note that the understanding general negligence is very, very crucial. If you have been, disorganized, please come back to the boat. We are still sailing. Now, understanding general negligence is very, very crucial in respect of the law of torts, because that will form the foundation for tortious actions such as vicarious liability, occupiers liability, negligence in relation to chattel, and even negligence misstatement. Negligence, is a shadow director, sir. So they will be operating under it. So when you understand general negligence, which happens to be a problem for some students, but which must not be, we will try and ask God may help us to break it down to the understanding of even people like myself, so that we will try and understand it. Let's look at general negligence. Now, when we speak of general negligence or negligence primarily, we are dealing with a situation where, car or diakobobi situation. And yesterday I heard a very sad story that ayalolobi ati break akotria for nipa so akumwomo. Omo ho asem ne yebeka ne hayi. Wo mo ho asem ne yebeka ne. Ayalolo driver no, woni ayalolo fo ni nyina, wo mo ho asem ne yebeka ne hayi. General negligence. General negligence. So we are going to look at that. Unless it was an accident, unless it was an inevitable accident, we are going to look at general negligence. So the point is that in negligence, you must know that in the case of Al-Hassan Kotokoli versus Moro Hausa, the court through Edusei J defined negligence to mean three and only three things. Where there is a duty of care owed by the defendant to take reasonable care such that his conduct does not affect the plaintiff. And in breach of that duty of care, the plaintiff suffers some damage. So there are three and only three elements to prove under negligence: a duty of care, a breach of that duty, and a resultant damage. What we are going to do at this juncture is to take each of them one after the other and discuss them. Note that general negligence is an action upon the case because it requires resultant damage. You must pay particular attention to that. So with your permission, I will speak to duty of care. Now, duty of care is the legal obligation or a legal duty imposed on a particular person by law to take reasonable care such that his conduct will not affect persons who are reasonably foreseeable to be likely to suffer from the consequences of his actions. Duty of care. It is a legal duty and not a moral one. It is a legal duty imposed on a person by law to take reasonable care such that his conduct or his actions does not affect another person who is reasonably foreseeable to be likely to suffer from the consequences of his actions. It is not a moral duty. That is why when you are walking in traffic and you meet a child in traffic begging for money, you are not under any legal duty to give them money. But if you go and you come back and they are dead, there will be no liability on top of you. But when you look at section 79, 80, 81, even of Act 29, there is a duty of care imposed on parents to take care of their children, imposed on spouses to take care of their spouses. You must pay particular attention. This is duty of care. Now, I need you to note respectfully that the position of the law used to be that duty of care only arises where there is a contractual or fiduciary relationship. In respect of the case of Candler versus Crane Christmas, Apentenadas versus Bank of West Africa, the court took the view that duty of care arises where there is only a contractual or fiduciary relationship. That is to say that in the absence of a contractual or fiduciary relationship, there was no duty of care owed. Then came our very famous Lord Atkin, in Donoghue versus Stevenson, where he developed his neighbor principle. And in essence, his principle is to the effect that you owe your neighbor a duty of care. And in determining who your neighbor is, he says your neighbor is any person who is reasonably foreseeable to be likely to suffer from the consequences of your actions. What it means is that to the manufacturer, your ultimate consumer is your neighbor. To the driver, other road users are your neighbors. To the teacher, your students are your neighbors. And to a parent, your child is your neighbor, because they are reasonably foreseeable to be likely to suffer from the consequences of your actions. So whatever it is that I say here, I owe each and every one of you here, including those writing the exam and those not writing, a duty of care, because somebody may rely on something that I'm stating and go and write this exam. So I owe you a duty of care. If I breach it, you can sue me for negligent misstatement. We are going to look at that. So in Donoghue versus Stevenson, you are very familiar that it is Mrs. Donoghue's friend that bought the ginger beer that had decomposed snail therein. It was in an opaque bottle. Now, some of you will lie to me and tell me that there was a snail in it. There's a snail cranny broth in the tree. And one no mokomoko. I want some snail, a decomposed snail, that the remains of a decomposed snail that they found under the ginger beer. The court took the view that even in the absence of a contractual or fiduciary relationship, unlike the case of Candler versus Crane Christmas, which you can see also in Apentenadas versus Bank of West Africa, a duty of care will be owed because of the neighbor principle, because to the manufacturer, his ultimate consumer is his neighbor. They developed this duty of care principle based on the neighbor principle, Lord Atkin. Then when you look at Caparo versus Dickman, the court now brought the test for determining duty of care, where they said that the harm must be reasonably foreseeable, and there must be proximate relationship between the tortfeasor and the parties. There must be proximate relationship between the parties, and it must be just, fair, and equitable to impose liability. This is the position of the law on duty of care. All I need you to note under duty of care before I move to the next element is the duty of care situations, where it deals with rescue situations and nervous shock situations. In respect of the rescue situation, the principle of the law is that if a defendant by his conduct puts a third party in peril, and it is reasonably foreseeable that the plaintiff will go to the rescue of that third party, then the defendant owes the plaintiff the same duty of care as he owes to the defendant. Let me give an example using the names of parties here in this meeting. If Angela Condria puts Baba Abu in peril, and it is reasonably foreseeable that Christabel Kuma
will go to the rescue of Baba Abu, then Angela Kondria owes the same duty of care to Christabel Kuma as is owed to Baba Abu. The point I'm trying to establish is that if my lady Nanaba puts my lady Gloria in peril, and it is reasonably foreseeable that Don Agbanyo will go to the rescue of Gloria, then Nanaba owes the same duty of care to Don Agbanyo as he owes to Gloria. The principle of the law is this: under the rescue situation. Now, everybody may say I was rescuing, and so on policy grounds, the courts have qualified persons who can undertake rescue situations. And these persons include, experts qualified in the field, parents moved by parental affection or parents controlled by parental affection. The case of Vidian versus British Transport Commission, and then persons whose ordinary line of work required them to rescue. Haynes versus Harwood, the policeman that saw the horse unattended to in a busy street and he went to save the public. The court said that there was a duty of care owed to him. I need you to note also and pay attention that busybodies are owed no duty of care. Even though Cardozo J has stated in Wagner versus International Railway Board that danger invites rescue, busybodies are not owed a duty of care. And that is the case of Cutler versus United Diaries. If you voluntarily assume the risk, then there will be considered to be no duty of care owed to you. And under the duty of care situations, you can also have the nervous shock situation, where the law allows you to sue and recover for the nervous shock suffered as a result of a breach of duty owed to you. Now, you can sue under the impact theory, where you are the primary victim, which is not even difficult to claim. But you can also sue under the shock theory when you are the secondary victim, in that you are not the primary victim, but you are proximate in terms of relationship to the primary victim and in terms of distance to the particular event. Here, the law requires proximity in terms of relationship and proximity in terms of distance. Look at the case of Boyhill versus Young. The pregnant woman saw the accident 50 feet away. The court took the view that she was not close as to be within the contemplation of a particular person. And then you can have the case of King versus Phillips, where the courts have taken the view that the mother who had the child 70 to 80 yards away, the court took the view that she was so far to be within the contemplation of the party. That is the Mamiya. Bring me baby. Mamiya, please mute yourself respectfully. GLM, you've raised your hand. Is there a contention? We will take the question subsequently so that I'll be able to finish. My lord, my lady Nanaba, please keep me on notice in respect of the time. Before I take you people to 1 a.m. Please notify me when the time is almost up. Now let's look at the nervous shock. Under the nervous shock, that is Boyhill and Young, King and Phillips, you cannot claim. But the court developed a concept called the immediately aftermath principle. That is where the plaintiff is proximate to the primary victim and he comes immediately after the particular event, he will be able to recover. This is it under duty of care. Then you come to a breach of the duty, which only requires that the defendant must have failed to exercise the reasonable care and skill required under the circumstances. Breach of the duty. If he fails to exercise it, then there will be such, as it were, liability. Paris versus Stepney Borough Council. There are something for friend of Paris. Paris versus Stepney Borough Council. The employer failed to provide the employee with goggle, and the employee suffered blindness in the remaining eye. The court said there was liability. But when you look at the case of Bolton versus Stone, the court took the view that there was no breach because even though it was a cricket that they were
Paris versus Stepney Borough Council. Even though it was a cricket that they were playing and it had gone off the fence to go cause harm to Mrs. Bolton, the court took the view that there had been reasonable caution or reasonable care exercised in the sense that there was a 17-feet fence, in the sense that there was a 17-feet fence which was actually constructed by the parties, and the ball had gone off the fence 6 times in 30 years. The court took the view that there was no breach. And then you come to resultant damage. Resultant damage. The law requires that there must be proof of damage, and that damage must have been caused by the breach of the duty of care by the defendant, and it must not be a remote one. Now, in discussing damages, the position of the law used to be that when it comes to damages, in in-re polemics, all direct consequences of the breach was recoverable. But under the Wagon Mounts case, the courts have come to a conclusion that it is only the damage that is reasonably foreseeable that is recoverable. Note also that the damage can be in relation to physical harm or physical loss or pecuniary loss. Pecuniary loss used not to be recoverable where there is no contractual or fiduciary relationship. Candler versus Crane Christmas. But in respect of asset where in respect of Headley Byrne versus Heller and Partners, now pecuniary loss is recoverable, even in the absence of a contractual or fiduciary relationship. So this is it under damages. And then you look at the defenses under general negligence, which are 2. We have volenting unfit injuria, which is a complete defense, voluntary assumption of the risk, which I have spoken about, Cutler versus United Diaries, and then also contributory negligence. That is when you contribute to the negligence. I mean, I've spoken about this. That is Jackson versus O'Connell, Owens versus Brimell. And then there is a principle under general negligence, which we will end it with. And that principle is the principle of res ipsa loquitur. Res ipsa loquitur, which literally interprets to mean that the matter speaks for itself. In respect of res ipsa loquitur, the matter speaks for itself. So that is that. Let me quickly and there you can rely on the case of Asafo versus Catholic Hospital of Apam. Asafo versus Catholic Hospital of Apam. I have vicarious liability, occupiers liability, product liability, and then liability for misstatement to finish. I'm hoping I'll be able to finish so that I can close the chapter on the law of tort, and then I can take the questions with your kind permission briefly, and then I would seek leave of you. Now let's deal with occupiers liability. Occupiers liability, what some people also call negligence in relation to premises. Negligence in relation to premises. Now, occupiers liability is the liability of an occupier. For the tort committed or for the harm suffered by persons who visit the premises. Now, I need you to have an open mind because it does not literally talk about, owners. Tenants, if somebody visits your premises and suffers some damage as a result, the liability that you will be incurred on you, that is occupier's liability. It is the liability of an occupier for any tort committed on persons who visit the premises. Now, I need you to note that for purposes of occupier's liability, visitors are categorized into 2 main forms. We have the lawful visitors and the unlawful visitors. Lawful visitors include, as it were, contractual visitors, include invitees, include licensees, and then persons who enter as of right. Whereas unlawful visitors include trespassers. Now, having laid your foundation like this, what is left is very simple. Who they are, the duty owed to them, and a case to support it. So let us quickly go through it, and then we will be good to go. Let's look at contractual visitors. They are persons who enter the premises in furtherance of a contract. They enter the premises in pursuance of a contract. Now, let me give you an example. Diana Hamilton and Mercy Chinwo collabo Perez Chapel, and you go to the filling station to buy the ticket. You want to go and listen to this. Is the doing of the Lord. What shall I render to you? All those. You have paid to be there. You have purchased the tickets to be at the premises. They are persons who have paid to be there. Not that you are paying them to be there, but they have paid to be there. And so the point is that contractual visitors are persons who visit the premises for purposes or in furtherance of a contract or in pursuance of a contract. They have paid to be on the premises. They include spectators at an event, spectators to watch a football match, hotel guests. They are contractual visitors. Now, the duty of care owed to them in respect of the duty is that there is an implied warranty that the premises are reasonably safe for the purposes for which they have contracted to be there. The law is that there is an implied warranty that the premises are reasonably safe for the purposes for which they have contracted to be there. What it means is that the court implies it, whether it is stated or it's not. There is an implied warranty that the premises are reasonably safe. And so a breach of this duty and its resultant damage will lead to negligence in relation to premises. Frances versus Cockrell, they contracted to watch a particular race course, and the seat that she sat on broke. There was liability. McLennan versus Seeger, the woman went as a hotel guest and occupied the place. There was a fire, and then there was damages. The court said there was liability. Then you talk about invitees, who they are. Invitees. So somebody is selling Kosiani Meko outside. You hear Kosiani Meko and you call Kosiani Meko into your house. Kosiani Meko is coming onto your premises for a purpose that you have a business, material, or economic interest in. So what we mean to say is that in respect of invitees, don't be carried away by the fact that, oh, they have been invited. It is not entirely so. They are persons who enter the premises for a purpose that the occupier has a business, material, or economic interest in. The occupier must have an economic, business, or material interest in why they are there. And so that is the position of the law. The Kosiani Meko seller is coming onto your premises because you want to taste it. So gas fitters, plumbers, electrician, all these people, they are on your land because you have an interest in why they are there. The duty of care owed to them is just a matter of one word, is that the occupier owes a duty to protect them against unusual dangers. So if the danger is usual, then there will be no duty. If it is actually one that no warning signs have been provided against, then danger ceases to be danger when warning signs are provided against it. The case of Indima versus Dames. Somebody said he can remember this case with Idima, Ejokwe. It's okay. If that is how you remember the case, we will pass this exam with strategy. I pray that as you study, as you prepare, God himself will visit you and help you. This journey, it is also a matter of God. So I pray that he helps you. Now, the point is that this is Indima versus Dames. He was a gas fitter and he fell into a hole. There was liability. And then we have licensees, persons who enter the premises only with the permission of the occupier. The occupier does not have any business or material interest in why they have entered. The occupier only has permitted them to be there. So long as he has permitted them to be there, the law imposes a duty on that occupier. So persons such as kayayos that you allow them to lodge at your uncompleted building, they are licensees, and persons that you have granted permission to be there. Lowry versus Walker, the defendant allowed members of the public to be able to use his premises to go to the railway station. He put a savage horse there and it caused danger to the plaintiff. The court said that there was liability. And then we have persons who enter as of right. The courts have taken the view that these are persons who enter because they have the legal backing to be able to enter. They have the law backing them. Meter readers, fire service personnel, police officers when they are effecting arrest and the arrestee enters a particular room, they have the legal backing to be able to enter. They are all the same duty of care as invitees. And so the law is that they are all the duty to be protected against unusual dangers. Then we can have trespassers, that is unlawful visitors. Trespassers are persons whose presence on the land is unknown to the occupier, and even if known, it is outrightly rejected by the occupier. Their presence on the land is unknown to the occupier, and even if it is known, it is outrightly rejected by the occupier. They are there not with the permission of the occupier, they are trespassing. The old position in the case of Addy versus Dumbrek was that trespassers were owed no duty of care, except a duty perhaps to protect them against concealed dangers. But presently, in Harrington versus British Railway Board, the courts have held that the duty of care owed to a trespasser is dependent on the common humanity principle, which common humanity principle is to the effect that if the tortfeasor is aware of the presence of the trespasser, or he's aware of the presence of the danger, and it will take him small effort to cure the defect, then there will be liability. That is the position of the law. And then we can quickly close the chapter with the case of Vidian versus British Transport Commission on the common humanity principle. You realize that the child that was on the railway line was a trespasser, but the father went to rescue that child. The court still awarded damages because the father was a rescuer. This under the common humanity principle. Children are most often than not protected. Remember, danger ceases to be danger when warning signs are provided against it. You close your chapter on occupiers' liability, whether it comes as a theory question or it comes as a problem question. My interest is at least for you to be abreast with the substantive law. I believe in that. So that you will hear a voice from behind that this is the way, walk through it. That you will hear a voice from behind that this is the way, walk through it. When you have studied, God will find a way to tell you that this is it, write it. And you will write it against all odds. Then the baby IEC people, after the exam, they'll be coming to do a postmortem. Where the occupiers liability, one occupiers liability, dear near where the one market paper nance and the mark here. Miss Tresams New Year, Kofi na koda. Untimi na ko antimony ho, na kodi antimony wache. Unim fufo joint bin so a, kona kodi bi ma homa will say from na sabre dia wo brew with him. Don't allow anybody to use postmortem to disturb your peace of mind. But papers no. God is the one that brings favor before your paper and before the examiner. So please be guided by that. We close the chapter on occupiers' liability. I can quickly look at vicarious liability, and then we deal with liability for misstatement, and then we can go. Let's look at vicarious liability. Asante fo wa sembi omoka. Womote kutre nkwawini makoma aponchirani nti hun fifre. It appears that vicarious liability is an exception. Mrs. Sachi in Sensemi, which row paper no so behawo. Kutre nkwawini makoma aponchirani nti hun fifre. But under vicarious liability, what it means is that ordinarily, everybody is liable for their thoughts. Everybody is liable for their thoughts. But under vicarious liability, an employer will be held guilty for the tort committed by an employee. That is it for vicarious liability. So vicarious liability is a situation where kutre employee na employer will be held liable under that. You must get this concept at the back of your mind, and it helps you to appreciate it. So when we speak of vicarious liability, it is the liability of an employer for the tort committed by an employee. It is the liability of an employer for the tort committed by an employee in the course of his employment. In the course of his employment. Now, there are two major elements to prove under vicarious liability. The very first one is that the tortfeasor is an employee of the defendant. That is the employer that we are seeking to hold liable. The tortfeasor is an employee. So the very first element is that you must establish employer-employee relationship between the parties. The second element is that the tort must have been committed in the course of his employment. Now, pay attention to this. There are instances where they will give you a set of facts, and it can require you to determine employer-employee relationship. It will be apparent on the face of the record. The tort or the vicarious liability will be speaking for itself. But there will be instances also where they will tell you that Kwabota is an employee of VRA. Kwabota is an employee of VRA. Then you are still going to raise the issue whether or not Kwabota is an employee of VRA. Question: it is not a fact in issue. You raise facts in issues. So when you are discussing the law, even though you will talk about employer-employee relationship, your focus will be on the second leg, whether he did what he did in the course of his employment. Please pay particular attention. Now, the very first element is that there must be an employer-employee relationship between the tortfeasor and the defendant. Now, to establish employer-employee relationship, the courts have taken the view that there are three tests that they will be used in doing that. The very first one is the control test. The control test. What it means is that the defendant must be the one controlling the tortfeasor. And I'm saying that the secretary ni oga ye bibi kakra bi anese secretary mom determine the time oga should come to work, but ordinarily oga should be the one controlling secretary. But you see, eniyama bi na esisi ntrana as eniyama anko yesana eniyama esisi. But the point is, he who controls who is the employer. He who is being controlled is the employee. That is the control test. And so whoever it is you are here, so long as you say you are working, whether as an independent CEO or as an employee, ask yourself who is controlling you. That person is your employer. They determine the wages, they determine your dismissal, they determine your appointment, they determine the mode of work, employer-employee relationship. And this was established in the case of Yewens versus Noax. And then you can have the case of Walker versus Crystal Palace Football Club. The court said that he who is controlling is the employer. He who is being controlled is the employee. The second test is the business integration or organization test. What it means is that the court will first of all consider the distinction between a contract for service and a contract of service. Now, a contract of service is where the tortfeasor does something which is so integral to the business of the defendant. So when you are engaged in a contract of service, what you do forms an integral part of the business. So GCB, any teller number 3, what she does forms an integral part of the banking business. But the fruit seller that is in front of GCB, even though what she does is for the benefit of the business, it is only secondary or ancillary to it. In law, we call the second people the independent contractors. The principle of the law is that an employer will be held liable for the tort committed by an employee engaged in a contract of service, but not one engaged in a contract for service. This distinction was made in the case of Stevenson versus McDonald. Now, I want you to pay attention to the case of Cassidy versus Ministry of Health. The plaintiff went for a normal routine operation, and the doctor, he came out with stiff fingers. So the court said that what the doctor does in respect of the business forms an integral part of the Ministry of Health. And so there was liability, there was an employer-employee relationship. And the very third factor under determining employer-employee relationship is the fact of, as it were, economic reality test, which deals with who owns the business, who bears the burden and the benefits of the business, and then who bears the laws of the business. Ready Mix Concrete Limited versus Minister of Pensions. You can get a question and they will tell you that somebody has been told to change his colors to suit the colors of a particular company. Now, who you are confused, I'm a person was said. So maamichi kosuanity ewo ukrom. Na so maami yamano Milo cap, Milo apron, Milo table can say table tenants. It's okay. Milo tablecloth and cap and everything and t-shirts. Milo. Well, even when your mother is wearing all these Milo things, especially the Maggie people, if they have all these things, are they employees of Maggie or are they employees of Milo? No. What they do, even though for the benefit of Milo, does not form an integral part of the business of Milo. And so they are called independent contractors. And that is what the case of Ready MTN, Momo, Ramadas, Yamishrao, Momo, no a painting in one yellow. Natadia Shannon Society yellow, a channel a yellow, when your best space yellow. So that does not make them an employee. That does not make you an employee. You are still considered as an independent contractor, and the employer will not be held liable for that. He will not be held liable for that. These are the tests in determining employer-employee relationship. But assuming you get a question and says that the person is an employee, then it means that you come to the second element. Which element is that the tort must have been committed in the course of his employment. In the course of his employment. What it means is that the court will be guided by certain tests in determining whether he did what he did in the course of his employment. The very first one is authorized act. If the defendant if the tortfeasor was doing an authorized act, he will be deemed to have been doing it in the course of his employment. Echijina versus Ej. The court said that where he is doing an authorized act, it is in the course of his employment. The second one is slight detour and frolics of your own. Now, those that know me know very well that I'm very particular with this pronunciation. Asantibe kwa etahame. Asantibe kwa etahame. So slight detour and frolic of your own. Frolic of your own. The point is, if you are doing your ordinary line of work and you make a slight deviation, a slight detour, such that you deviate slightly, your employer will still be held liable. But if you deviate completely from what you are normally doing, then your employer will not be liable because you'll be deemed to be acting in the frolic of your own. Let me give you an example. A delivery guy who has the delivery van, if he decides to park at Antimony and eat Antimony wache, and then the van, because of his failure to pull the handbrake, it reverses and causes danger to somebody. That eating of Antimony wache is a slight detour. But assuming you are from Asifosu, they tell you to deliver something to Asifosu, and you said that, oh, ma meti asanti be kwa heya ntiene ma memfa adwuma mu kaa no, memfa nkwochia me ma memra sisia. Between Asifosu and Asanti be kwa, you are in the frolic of your own. You are in the frolic of your own. Please, some people are as it were, unmuted. Please, Kwame Mensah Darko, Seth Elton, you are unmuted. Please mute yourselves. Thank you. If you go on a complete deviation,
you've mistakenly muted.
If you go on a complete deviation, you will be considered as, being in the frolic of your own. Story versus Ashton. A delivery guy, he used the delivery van to go and meet his brother-in-law. Complete deviation. As Attorney General versus that day, the fire service personnel used the service vehicle to go and, as it were, look at, drop a brother home. The court took the view that that was a complete deviation, and so there is no liability. The third pointer or the third factor is criminal act. The law is that if a tortfeasor commits a criminal act whilst working, if it is closely related to his work, then the employer will still be held liable. But if it is not closely related, then the employer will no longer be held or liable. Halsey versus Leslie Hall. He was a ward in a particular school annex, and he was fingering their children. The court said the employer will be held liable. The fourth factor is negligent or careless act. Negligent or careless act. If in doing his conduct or what is required of him, he does it negligently or carelessly, notwithstanding his negligence or carelessness, the employer will still be held liable. And here you have the case of Century Insurance Company Limited versus Northern Ireland. Negligence or careless act. The tanker driver, he was filling the tanker car and then he lighted up, as it were, a cigarette, failed to quench it and threw it, and there was fire. The court said the employer will still be held liable. And then there is final one, express prohibition. The position of the law is that notwithstanding the express prohibition by the employer, if the tortfeasor, that's the employee, does the express prohibition, the employer will still be held liable. Limpus versus London Omnibus Company Limited. They proscribed them from overtaking and careless and unnecessary driving. He did it, and then there was still liability. This is how you determine employer-employee relationship, and then whether he did what he did in the course of his employment. Then somebody may want to know why vicarious liability. Why vicarious liability? The position of the law is that the employer is the one that has the deep pockets. The employer is the one that has the deep pockets. And from those of you from Prof. Brain Institute, respectfully, I told you that if between myself and Prof. Brain, you want to sue somebody, sue Prof. Brain because he has the deep pockets. If you dip your hands in my pockets, blade is what you will find. You will not get any money. All right. So the employer is the one that has the deep pockets. And then you can also have the fact that it serves the loss distribution function of the law of tort. And again, it enables the employer to exercise reasonable care or exercise caution or supervision on his employees. And then he who bears the benefits of the employee must also bear the burden of the employee. It must be noted and you must be guided. And finally, the duty that has been breached is actually a duty owed by the employer to the third party. Abusia, we close the chapter on vicarious liability. I have product liability, which is very simple. Let me quickly deal with it. My lady gave me 9, but I have product liability and liability for misstatement. Let's see whether whatever the team will decide, I would negligence and careless act. You have the case of Century Insurance Company Limited versus Northern Ireland. Let me quickly touch on product liability. Now, what kind of product liability? Now, one kind Donoghue and Stevenson, you are gone. Are irredeemably gone. So the moment we speak of product liability, at least you must remember your case of Donoghue and Stevenson. Now, product liability is the liability of a manufacturer for having produced a defected or having manufactured defective goods, which has caused danger to the ultimate consumer upon consumption. So that is the point we are. Oh, my lady Nanaba, my lady, you can, Miss Ramumunya, but message. My lady, you can proceed. We are here for you. As Danke Radio was through. So let me finish, please. Now, the point is, in respect of, as it were, product liability, it is the liability of a manufacturer for having manufactured defective products. So when the manufacturer manufactures defective products, then if the plaintiff is the ultimate consumer and he has suffered some damage, there will be liability. Now, to prove product liability, there are certain elements that the plaintiff must prove to succeed. The very first element is that the defendant is the manufacturer. 2, that he has manufactured a product. Thirdly, that he put up the product for sale. Fourthly, that the plaintiff is the ultimate consumer. Additionally, that there was no means of intermediate examination. Furthermore, that there was a breach of a duty owed by the defendant. That is, there was some negligence in respect of the defendant, and then the plaintiff has suffered some damage as a result. Now, there was something we used to do. We used to move from shop to shop to find the spoiled, the expired Don Simo. When you open it, then you taste it small. If the taste is normal Don Simo, and say it, we consume it. That cannot come under product liability because such situation, the producer or the manufacturer has not put up that particular product for sale. And so be guided. The manufacturer must be, the defendant must be the manufacturer. He must have manufactured the product. He must have put that product up for sale. The plaintiff must be the ultimate consumer. There must be no intermediate examination, or there must be no reasonable means of examination. And then there must be breach of a duty owed by the manufacturer, for which reason the plaintiff has suffered some damage. Of course, between actionable per se and actionable upon the case, you can clearly tell that product liability or negligence in relation to chattel is an actionable per se action. You must note that, and cases to support you, a number of them. Donoghue versus Stevenson, decomposed snail found in the ginger beer, which was in an opaque bottle, satisfied, even though there is no contractual or fiduciary relationship, satisfied. Then you can have the case of Abuaje versus Kumasi Breweries Limited. Abuaje versus Kumasi Breweries Limited. There they found the decomposed palm fruits in the beer, the satisfied. Then a Champion versus Overseas Breweries Limited. There was kerosene mixed with the beer, satisfied. And then you can have Grand versus Australian knitting mills. You have a golden fleece woolen underwear, which had excess sulfur in it, satisfied. Because the underwear, it is not now that you are going to put it under horoscope. I don't even know what horoscope is, but I've said it. Telescope or monoscope, you are now going to put it under it to determine the amount of sulfur there is in it. Please pay particular attention to product liability and some of these cases, but don't forget the agency or the commercial principle of, caveat emptor, caveat vendito. Buyer beware, seller beware. That is why the element of intermediate examination comes in. Because Smirnoff ice, that's a board here. You should know, because that one is not in an opaque bottle. But if you buy better malt, or you go and buy your coat for part 1, which I know some of you may have bought already, step in faith or step of faith. So if you buy your coat and there is excess sulfur in it, then there will be a liability, because machine the amount of sulfur therein. We close the chapter on product liability. And then finally, in respect of the things I will deal with, will be liability for misstatement. This part is very important to me, because I've been sending some nuggets to some people by way of who am I? I mean, it's we play with the law. Those that I have their numbers, we play with the law in terms of who am I? And then I sent a nugget to them, and somebody would tell me the area of matter is liability for misstatement, particularly fraudulent misrepresentation, negligent misrepresentation, and then innocent defamation. Let me draw the distinction here, please. Last year, the question that came, those people that didn't read the requirements of the question first, my lady Nanaba, the moment I finish my submission, please remind me that I said I will tell the members something about reading requirements. Please remind me. Once you remind me, I'll remember what I want to say. Thank you. So I'm saying that those that didn't read the requirements of the question at the bottom first, they started writing on fraudulent misrepresentation, because the question has, as it were, been in respect of, semi-fraudulent misrepresentation, negligent, deceit, semi-fraudulent, semi-defrauding by false pretenses. They have similar facts. They can be similar. Obiswa Kwame Eugene, Castro again, no feature, baby jet. They are all similar. All right? Or the person will come to you and tell you that I am Kwame Eugene, rock star. They are all similar. but there is a way to distinguish between them. When it has to do with the crime aspect, it is even easier because last year the requirement was discuss the criminal liability of so and so. That is even easier to detect. But what becomes problem is when it is contract or tort. So let's look at it this way. So we are convinced that under contractor, the topic, the matter is misrepresentation. The elder brother is fraudulent misrepresentation. The younger sister is negligent misrepresentation. And the last born is, as it were, innocent misrepresentation. But if you are confident that it is under tort, then it is deceit, negligent misstatement, and defamation. They all come under liability for misstatement. So Abusiamen can't say misrepresentation with specific reference to deceit. And shut down faster. So please know where you are putting each of them and how you will be able to detect them. It's the principle in legal system that you will learn. In interpretation, nocete as sources. A word is known by its associates. So last year question is say semi-fraudulent misrepresentation, but it came with inchoate offenses. Now I will cite fraudulent misrepresentation. Who has cited inchoate offenses? So if you get a question like the one that came last year again, if it has a bit of some, offer and acceptance, be kakra, and intention kakra, consideration kakra, be shasia ho kakra, not semi fraudulent misrepresentation, semi deceitor, nurse, and no dear, a contract, dear no. Me say, when you want to distinguish between the two, contract, dear, a misrepresentation. Ne mano fraudulent misrepresentation, negligent misrepresentation, and innocent misrepresentation. Tort to the your friend liability for misstatement. Ne mano deceit, negligent misstatement, and defamation. And a criminal law, the or no the one penny was him to one and no. Your friend defrauding by false pretenses, contrary to section 131 of Act 29. You must be guided. So please know which one you are talking about. So let's pay attention. Now, liability for misstatement may be seen in the nature of deceit, in the nature of, as it were, negligent misstatement, and in the nature of defamation. We are going to look at these three and then we will conclude on our discussion. In terms of deceit, we are talking about all the situations where Castro alike look alike will come to you and tell you that I am Castro again, Fichi, baby jet. The point we are trying to establish is that in fraudulent or in deceit, I beg your pardon, it deals with a situation where the defendant makes a false representation fraudulently to the plaintiff, intended to be relied on by the plaintiff, which he actually relies on it to his detriment. Now, the point I'm trying to establish is that in Derry versus Peak, the court said the major element under deceit is the element of fraud. And they said that fraud means that where you make a false statement of fact knowingly, without any honest belief in its truth, recklessly careless whether it be true or not. That is the position we are trying to establish. That is the point of the law. Derry versus Peak. You know that the only reason for Derry and Peak failing was because the man they made that statement, the prospectus that they sent out, it was in honest belief in the truth of it. And so that is that. But when you look at the case of Kusi versus Kusi, the court laid down the elements of deceit, where the court said that the defendant must have made a fraudulent statement. Secondly, he must know it to be fraudulent. Thirdly, he must make it with the intention that the plaintiff will rely on it. Fourthly, again, the plaintiff must have actually relied on it. And then finally, he must have suffered some damage as a result of that reliance. And so in Kusi versus Kusi, he went and used family property to secure a loan as his personal property. The court upheld deceit because it was made, fraudulently. In fact, same principles, even Derry and Peak, when you are talking about fraudulent misrepresentation, you will still cite it. But the additional case that you will cite under contract law will be the case of Edgerton versus Fitzmaurice. It is easy to comprehend, know which one falls under which one, and where you are coming under. And then we can look at negligent misstatement. Negligent misstatement deals with a situation where the party owes a duty of care to make correct and accurate statements to the the plaintiff, and in breach of that duty of care, he makes an incorrect and inaccurate statement to the plaintiff with the intention that it will be relied upon by that plaintiff, and that plaintiff actually relies on it to his detriment. This is the position of the law. This is something you must note. That is negligent misstatement. Note that from Candler versus Crane Christmas, Apente and others versus Bank of West Africa, a duty of care will only be owed where there is contractual or fiduciary relationship. But in respect of assets where the present position, Headley Byrne versus Heller and partners, a duty of care will be owed even in the absence of a contractual or a fiduciary relationship. This is the position of the law. That is the point we are trying to establish. You must note, Headley Byrne and Heller and partners suffices as your recent position. In fact, when you are talking about negligent misrepresentation, these are the same cases you rely on, and add maybe the case of Nocton versus Lord Ashburton, and then the case of Esso Petroleum versus Madden for negligent misrepresentation. But in negligent misstatement, it speaks to the same principle. And then you come to asset where defamation. Perhaps the very final topic I will treat for tonight, and then I will make room for questions. Defamation. Now, if somebody tells you as an actor or an actress that you are hideously ugly, what do you attempt, papa? That's a patch that's a time money. So the point is that defamation, when you look at Article 21 of the 1992 Constitution, it secures a person's freedom of expression. You can say whatever it is you want to say, but Article 12, Clause 2 of the 1992 Constitution says that your fundamental human rights is subject to the fundamental human rights of another person. That means that your right ends where another person's right begins. And in essence, if you have the right to freedom of speech, you must not extend or go beyond ruining the reputation of another person. So in defamation, it deals with a situation where the defendant makes a false statement, makes a statement capable of having defamatory meaning, which is in fact defamatory, and he makes it in reference to the plaintiff. And the plaintiff, by way of publication, and the plaintiff suffers some damage as a result of it. I will pick these elements one after the other and explain them for you to understand. In respect of the words capable of having defamatory meaning, which is the first element, the courts have held in the case of Sim versus Stretch, as affirmed in Anas versus Kennedy Ohina Japan, that where the statement is capable of having defamatory meaning, it means that it is capable of lowering the plaintiff in the estimation of right-thinking members of society. What it means is that it lowers the plaintiff in the estimation of right-thinking members of society. The plaintiff will be subjected to ridicule, shunning, avoidance, or people will begin to disassociate themselves from him. Assuming you are eyeing a certain girl, intending to marry this certain girl, and somebody goes to the mother of this certain girl and tells the mother that so for that reason, the mother says that because you are a murderer, I'm not giving you my child. The point is that the words are capable of having defamatory meaning. Sim versus Stretch. In Anas versus Kennedy Ohina Japan, when the court said that to call somebody a fraudster, a murderer, a whatever, all the things that my Lord Kennedy said, it was capable of having defamatory meaning. And then you have the second element, which is that the words must actually be defamatory. The words must actually be defamatory. What it means is that when interpreted literally, it must be defamatory. It must be defamatory. That is the point we are trying to establish. When it is given its literal interpretation, it must be defamatory. Mrs. Abna Pokia Aka versus Agricultural Development Bank, Anas versus Kennedy Ohina Japan, the case of Berkoff versus Birchall, the court said that to tell an actor that he is hideously ugly amounted to a defamation. And then the third element is that it must be made in reference. Please, let me read this message. Someone has sent a certain message. Someone has sent you a message. Please, I beg, send me the pointers. My name is Dr. Paul Jan. The point is that it must be made in reference to the plaintiff. That is the fourth element. It must be made in reference to the plaintiff. What the point we are trying to establish is that being made in reference to the plaintiff need not necessarily mean that the plaintiff must be mentioned expressly. It may be that all circumstances will be pointing to that plaintiff or so far, so they may not have expressly mentioned your name, but all circumstances point to this. And I need you to draw your attention back to last year's question. It was only one person that was standing for that election. They didn't mention the name of this man, but we all know the man that was standing for the election. Reference has been established. Professor Adekulu versus UDS, University of Development Studies, and then Anas Arimiyao Anas versus Kennedy Ohene Japan. And the fourth element is that there must be publication. There must be publication. There must be publication. Publication here means that in respect of, as it were, publication, we are talking about a situation where, the plaintiff has made known the defamatory statement to at least one person other than he who is himself being defamed. The plaintiff has made known a defamatory statement other than he who is himself being defamed. And so in half and half, the court said that if the publication was made by way of illegal means, if the party came to be aware of it illegally, then there will be no liability. But there must be publication. Anas Arimiyao Anas, he went on radio station, TV station, among others. And finally, there must be damage suffered by the plaintiff. The commonest form of damage here is reputational damage. The commonest form of damage here is reputational damage. And so you must note that. Saville versus Roberts, he says damage can be to your name, to your person, or to your property. Ladies and gentlemen, he who is sued under defamation may have certain defenses. Absolute privilege is the first one. That is a complete immunity that exonerates the party completely from liability. And then you can have, so judges, members of the judiciary, the executive, the legislature, they enjoy complete immunity. And then you can have qualified privilege. That is one that, there is some immunity, but not a complete immunity, like the ones that the media personnel enjoy. And then you can have, as it were, fair or honest comments. If it is a matter in the interest of the public and you make a fair comment on it without any malice or anything, then there is liability, or there will be no liability because it's a fair comment or honest comment. And then fourthly, or in addition, you can have truth or justification. This is what availed to my Lord Kennedy Ohene Japan when he was sued by Anas Arimiyao Anas. At least the High Court's decision, there was held to be truth or justification because he was able to lead evidence to prove the truth of some of the allegations. And then finally, you can have consent. He who consents to a thing cannot complain of trespass. Of course, he who consents to a thing cannot complain of trespass. And then he who is suing for defamation may seek for certain remedies. And some of those remedies may include injunction. If the thing has been made but is yet to be published, then they can seek injunction to restrict the movement, the publication thereof. And then you can also have, as it were, damages. And then you can, in the form of monetary compensation, and then you can have retraction and apology. Retraction and apology. There is a case between Martha Nkoma and Kojon Kansan Lewin. So you may want to also pay attention to that. I heard it that there was also liability for defamation thereunder. Ladies and gentlemen, with your kind permission, as far as entrance exams is concerned, as far as your preparation towards the exams is concerned, this is the little contribution that I can make to it. My lady Nanaba, please. My lady Nanaba, I want to do something with you. I want to do something with you on behalf of all the students here. Each one of them will do it separately in respect of from where they are. But you will unmute yourself and do it generally. There is something that I have observed, and I want students to pay particular attention to it. Anytime you get a problem question, please go to the bottom of the question and read the requirements of the question before you start reading the set of facts. For a reason, it helps you to know what the question is requiring of you. So you can read the whole set of facts and you get to the bottom and it says that discuss the liability of the person and any defenses available to the person. You didn't read, you didn't pay attention to defenses, so you would have to go back. And if the question is like 1.5 page, read the whole 1.5 page again. So by way of curing this waste of time, my lady Nanaba, you will say I, then you mention your name. Everybody will say it. Everybody. I, Maria Abrefi.
I, Nanaba Kwisenwa Odum.
When I get my question.
When I get my
question.
When I get my question.
Those of you saying it, mute yourselves so that you
pay
will say
attention
it
to the
in one
question. They said mute yourselves. I beg you.
Mute yourself so that Nanaba will respond on behalf of the team. So I, Maria Brefi.
I, Nana Abakwisenwa Odum.
Now what will cast us one kind requirement no now start wasting time make pay well die. So I, Maria Brefi.
I, Nana Abakwisenwa Odum.
When I get my question.
When I get my question.
And it is a problem question.
And it is a problem question.
I will go to the bottom of the question.
I will go to the bottom of the question.
To read the requirements of the question.
To read the requirements of the question.
Before I go and read the set of facts.
Before I go and read the set of facts.
The reason is that.
The reason is that.
I want to know the requirements of the question.
I want to know the requirements of the question.
And be guided whilst reading the set of facts.
And be guided whilst reading the set of facts.
So help me God.
So help me God.
If you have said this, my lady Kwansima, you are the best. If you have said this, and you don't do this, and you waste that 2 minutes going to read the set of facts again, I will appear before you in the exam room. In the exam room. Please, it is only for your benefit. It is to help you. At least, even if it is advise the parties, it's okay. At least when you are reading, you will be going round and be looking for the parties that you are supposed to advise. Kwabuta, Kwamentra, Kwambobie, Antiage, Memuna, Bontebe, the star girl. You are advising all of them. You must be guided. You must be guided. You must be guided. Please, are we together? Yes, my lady. Please, in respect of my submission, I think that this is the little that I can contribute. If there is anybody that has any question, I don't have a problem if you share my number. It's so long as it is academically related. Hey, financial help, I'm broke. I cannot help you. Financial help, I can't. But if it is academically related, we can discuss it at least before you write the exam. We are in this together. We stand with you in prayers and in any way that we can support to assist make this journey a worthy cause. I will be one of the happiest people if you send me a message when the results is released. Yeah, my lady, I made it. May on that day, I will shout. Yes, my lady Kwansima, respectfully, I can take the questions now.
Yes, please.
I can take the questions now.
Much because we have limited time, we'll take just 5 questions. So if you have
5 questions,
yes, for now.
but I'll share my lady's contact with us all so that if you have any questions, you reach out to her. However, for now, we are taking just 5 questions. So please, if you have a question, kindly put your hand up, raise your hand, and then I'll call you. Thank you. Okay, so Princess, please, you can unmute and ask your question.
Help us with differences between defamation and innuendos.
So you see, defamation may be, direct defamatory statements, right? Innuendos may be like an insinuation. You are not really, I said, I didn't know proper anymore, but you are, when you look at it closely, it brings down the reputation of the person. So innuendo may be in the form of, not so clear defamation. You are not really, Sabio, okachira akra woko school say, Sabio, uchi trogankeye. I mean, trouble so yeah, but you know what we are talking about. Accra Woko School, GIS, and I say gay. Now, catch them senti, we are sure say school will buy and now person trouble. You have not defamed such a person, but I mean, insinuatively, you are defaming the person. So innuendo is more like, an not so clear form of defamation. The person may be insinuating something. The person may not feature the case or the matter and tell you that this is what I think about you. So the person will not tell you that you are hideously ugly, but the person will tell you that me chimpanzee. That's an insinuation. We do attempt. So ɛwɔ anafoɔ hɔnom wotwa mu kɔ hyia wo nua na sɛbio bɔdamfo a wɔte hɔ anasɛ I mean chimpanzee ni abɔ ne tie ɛna wɔte hɔnom ɛsɛ wɔdi watempa wo ho ɔtan. So for innuendos, right, it may be in the nature of some insinuation, or the person may not point to the face of it to say that, oh, I'm insulting you, but the person will just have a way to, I mean, tarnish your image, or as it were, bring down your name into disrepute. I hope it helps small. I mean, at least small like this, peon like that.
Yes, please, my lady. So just a quick one. So the last year question, was it innuendo or defamation?
I will treat it under defamation, and in discussing that, I won't forget to touch on innuendos. I will treat it because, you see, whenever you get a set of facts, this is what I want you to do. Pam kabane slit. Nafa set of facts ne sheno. Say it is it. That's why I always tell the people that I meet that if it is walking like a duck and it is quacking like a duck, most definitely it will be a duck. So the point we are trying to establish is that when you see last year's question, fix it into defamation. Does it fit? Was there a word capable of having defamatory meaning? Was it actually defamatory? Was it made in reference to the plaintiff? Was it published? Was it in relation to, as it were, did the plaintiff suffer any harm as a result? Once you fix it into these elements and it fits, you are better off discussing it. And if it comes as a full question like that, you can even discuss the innuendo. And even if it doesn't apply, in your application, you apply the part that relates to the question. So I would have treated it under defamation primarily, generally speaking, because I think that it fits under all the elements of defamation. Any further questions? Any further questions? You are very welcome, my darling.
So, my lady.
Yes.
So if we have, in answering the question, if we have criminal, can we use a section from the criminal law?
Oh, so long as it is, you see, when I was discussing unlawful arrest, I used a section from the Act 30. So long as it relates to it, right? So long as it relates to it, you can use it. But the point is that If it has no business with this thing and you want to cite authority, so you are concocting, then you go and tell the examiner that Article 1 Clause 1, which speaks to constitutionalism ordinarily, it speaks to constitutionalism, but Article 1 Clause 1, you go and tell the examiner that that is trespass to land. You are lying. So unless you are very sure that it applies mutatis mutandis to what you are talking about, if it does not have any relationship at all, don't concoct. You either annoy an examiner who realizes that you are trying to force yourself to cite a case or to cite an authority. That's why I always will tell you that if it is in relation to cases or authorities, if you know it, cite it. But if you don't know it, in particularly the case, you are better off saying that the courts have held or it has been decided, better than saying that under private nuisance, the case of Tufuo versus Attorney General. So that is it. That is it. Any further questions? Any further questions, respectfully?
Thank you.
Hello.
Please.
Hello.
Do we have any
Yes.
other question?
Yeah, hello.
Okay, Francis, you can speak.
Yeah, please. I want the distinction between independent contractors, contractor visitors, and then the invitees with some examples.
Independent contractors. You let me discuss the contractual visitors. Persons who enter because they have paid to be there. My lord, if you go to Paris right now or Bahamas and you decide to pay and lodge at a hotel, you are deemed a contractual visitor because you have paid to be there. If you go to school, you have paid school fees to be there. You are a contractual visitor. All of you that will be going to the Ghana School of Law in no time, I hope you are putting your money also by the side before they will come and say you have 1 week to pay 10,000 Ghana cedis, and then you will be finding yourself wanting. Oh, this Ghana no jakakra. Now they are doing change. So once you pay to be there, you are a contractual visitor. If you pay to, as it were, go and watch a football match, you are a contractual visitor. But invitee, Kosiani Meko, when Kosiani Meko is passing, and you call Kosiani Meko to come so that you buy Kosiani Meko and eat it, that person is coming there because you have an interest in why they are coming there. A gas fitter, a plumber, a POP guy, see, when they come to your premises, they come there because you have a purpose for which they are coming there. Under contractual visitors, there is an implied warranty that the premises is reasonably safe for the purpose for which they have contracted to be there. Frances versus Cockrell, McLennan versus Seeger. Then you come to invitees. That is persons who you have a material interest, business or commercial interest in why they are there. You have the case of Indima versus Dames, the gas fitter case. But the other one that you spoke about, independent contractors, I don't know where you are fitting it under. Is it under vicarious liability or any? Is it under vicarious liability?
Occupiers liability.
Independent contractors.
My
Under
lady, I think
occupiers,
he means the licensees.
he means what?
Maybe the licensees.
The licensees.
Yes, please.
So the licensee, if it's in simulation to the licensee, there are persons who enter the premises because you have permitted them to be there. You have only allowed them to be there, like your friends, your family members. So umame nuya bi ba wo wedding. Ena mama no guest room hɔ sɛ wɔntena hɔ. Na sɛ 17 years ago, wedding nti wankɔ akura biem a, she is not a contractual visitor. She's not an invitee. She's a licensee because you have permitted the person to be there. Please, do you understand? So those are the kind of people we are dealing with. Lodgers, purchasers, those people, they may be
Okay. So
licensees.
what about painters, electricians, and the rest? When they
They
come to your
are
house to work?
invitees. Painters, electricians, they are invitees. They come to your premises because you have a purpose for which an interest in why they are there. They are coming to paint your room for you. They are coming to fix your electricity gadgets for you. They are invitees. Don't be deceived by invitees to say that they are the persons you have invited. No, they are the persons that you have an interest in why they are there. Of course, you would eventually invite them, but you still have a material, business, or economic interest in why they are there. Yes, any further questions? The last thing I would want to do for all of you before I proceed, please, is to pray with all of you. So please, if you are still here, please wait. Let me pray for you before you go. I beg you. Yes, my Lord, my Lord.
Hello, my lady.
Yes.
So with the licensee, what is the level of liability?
You owe them a duty. You owe them a duty to protect them against concealed or hidden dangers. Concealed or hidden dangers. Dangers that are hidden. I'm talking about the case of Lowry versus Walker. So that fact of Ponkwa is a concealed danger. That is why in Lowry versus Walker, the occupier had to protect the members of the public that he had allowed to use his lawn to the railway station from such a savage horse. Yes, any further question?
Okay, my lady, we'll take the last question from Ajwa, and then I'll send your number to the rest. Okay, Ajwa, please.
Okay, so my lady, I wanted to ask a question about the duty of care. Can you please explain that one briefly? The duty of care under I'll have some
and the
duty of care.
The duty of care, it deals with hello. Hey, everybody. The duty of care deals with the legal obligation imposed on a particular person to take care such that his conduct will not affect persons who are reasonably foreseeable to be likely to suffer from the consequences of his actions. Please, is that clear? That is the duty of care we are talking about. It is not a moral duty. It is a legal obligation. It is a legal obligation. So the point is that it is not a moral obligation. It is a legal obligation. So that is that. That is that. Please, is that clear?
Yes, please.
Okay. All right. Let's look at the point. Let's look at the last question, and I will try and pray for all of you so that we can go.
Okay, my lady, someone has asked the question which states, at what time does a duty of care arise in the case of medical negligence?
Sure. What kind of a duty of care arise in the case of medical negligence?
At what time?
At what time?
Yes.
When the doctor, the doctor owes a duty of care to the patient. If he breaches that duty of care in any way, when he fails to exercise the reasonable care that is required of such persons, then there is a breach. And once there's a breach, a duty of care will arise. There was a recent case between one of the hospitals, I think Nyaho or whatever, I don't remember. But a doctor left something in the stomach of the patient. That is medical negligence. It is also under general negligence in relation to the duty of care. Please read the Bolam test. My Lord Adewi is guiding us. So when they leave cutlass in your stomach, that one, you can go ahead and sue. And that one, it will be easy to determine because res ipsa loquitur, the matter will be speaking for itself. Please read the Bolam test and you'll be guided. You'll be guided. All right. Any person, any further, my lady, at this point, I think that.
Yes, please.
Yes. So with your permission and with the leave of the team, please, if there is anything to be said, let's say it before I share my final prayers with the team.
Okay.
And then.
Yes, my lady. So on behalf of the team, we would like to thank you very much for today's session. At least I have also learned law in Asante Bekwai.
At least I've picked one or two things from you. We are so grateful for your time today, and we hope to have you tomorrow for criminal law.
No problem.
Yes, please.
No
So
problem.
we'll have you tomorrow for criminal law, and that would also begin. That will begin at 7 p.m. So tomorrow,
Okay.
criminal law at 7 p.m. We are really grateful for your time today. So please, all those that join, you can inform your friends to also make time to join us tomorrow at 7 p.m. This is where we end the class for today. I would hand over to my to end the class for us with a prayer. Thank you.
All right. Please, I'd like to pray
The
for
number.
Yes, please.
each
I'll
one
make
of
that
you.
available. Don't worry.
I'd like to pray for each one of you. Now,
We put the recording
there
on the
is
main platform.
Yes, please.
there
The
is
recording would be provided.
please,
thank
and those of you right here, as I indicated, I am a lecturer at Prof Brain Institute. I'm praying that God will grant you admission. But once you get to the law school, don't forget we are organizing Prof Brain classes for part 1 and part 2. You may want to come so that we learn the law together. Now, let me pray for all of you.
Please, just a
Let me
minute before you pray. Please kindly follow our various social media handles. We'll put them on the pages so that you can follow them, so that you can get up to date information. Today, for instance, we had to shift the time to 6 p.m. and we realized that quite a number did not realize that we had shifted the time. So kindly follow us on all social media platforms so that you know what is happening at what time. Thank you very much. My lady, please, you can take over.
There's a spirit in man, and the breath of the Almighty giveth him understanding. We thank you, precious Holy Spirit. We bless you for who you are and for what you have done. We trusted you, and you showed up, and you made a name for yourself. I pray committing persons on the other side of the phone to your hands. 1 Samuel 38, and David inquired of the Lord, shall I pursue? Will I overtake? And the Lord answered, pursue, for you will surely overtake them, and without fail recover all. May God keep his word in your life. May, if God is choosing people he wants to show mercy as far as this exam is concerned, may each one of you be one of them. May the grace of God abound, and may the hand of God be filled upon your life. Let the mercy of God be upon your life, so that all glory will be given to him alone. You will have a reason to jubilate. You will have a reason to celebrate. You will have a reason to thank God, and your generation will have a reason to thank God, because all of them trusted God on your behalf, and he has delivered. May God take care of you in terms of strength. May he grant you divine ability, capacity, and tenacity. May God widen your scope in these few days that is left, so that you will be able to achieve greater heights. In the name of Jesus, I have prayed. Amen. My lady, to the entire team, I want to say thank you once again. I want to say thank you.
Amen.
I want to say thank you once again.
Yes,
Have
my
a
lady. God
wonderful
bless
day.
you.
Have a
Amen.
wonderful day.